Yes.
I vote to memos.
Yes.
One is of the year, proceeding in the trial court comments to the year 2010. Whether in the condition or not, the only decisive factor to be taken out of in this appeal. Other pleadings are admitted. Only one sentence running in the gift, whether it is a gift condition or not.
Yes.
Hardly it may take about half an hour any day to remember.
24.
Okay. And another memo, my lord has heard it, updated as a partner. Proceedings commenced in the trial court of the year 2008.
Yes. 6 program. 6. Yes.
The trial court 2008 ನಲ್ಲಿ ಆಗಿರೋದು.
ಅಲ್ಲ RFA ಯಾವ year? 16 ನಮಗಿಲ್ಲ, it is not our roster.
Page number 1, serial number 1 to 7. Page number 7.
Yes.
Office objection 5th time.
Why you have not complied for 5 times? Mr.? Yes, at the request. Finally 2 weeks.
5 Margin D.
2 weeks.
6
2 weeks.
Page number 2, serial number 8 to 13. Prasad PS.
Yes. 2 weeks.
Page number 3, serial number 14 to 17.
15.
5.
Yes.
Page number 4, serial number 18 to 21. Page number 5, serial number 22 and 23.
2 weeks I take steps for 5 years.
2 weeks to do the needful.
Page number 6, serial number 24 to 26. Page number 7, serial number 27 to 30. Page number 8, serial number 31 to 34. Page number 9, serial number 35 to 39. Page number 10, serial number 40 to 43.
Yes, you are appearing for?
42 M. Shivaprakash.
Karnataka State Vedamurthy IFR vacating non-filing of paper book. Yes, finally 2 weeks time is granted to file a paper book.
Page number 11, serial number 44 to 48.
Still number 48, my lord. I appear for, please, I am for appellant. 2 weeks time, my lord, I'll file paper.
Which finally to file paper book.
Interim order 2 weeks.
Interim order granted earlier if any is extended till next date of hearing.
Achha.
Page number 12, serial number 49 to 52.
Serial number 49.
49 Prakash KA.
For what it is posted for impleading. What is that impleading? Let us see. We'll see when the matter is reached. Yes.
Besides that,
For objection, non-filing paper book. Yes, 2 weeks to file paper book.
51. 2 weeks.
This matter posted for final hearing. Hearing.
You are appearing for whom?
Appellant.
No, who is appearing for respondent?
Swami
I will inform to it.
Have you informed?
I will only.
Also, you informed because there is an IFR vacating.
Please, ma'am.
Yes.
Last date of hearing, honorable court to post it for final hearing.
You inform other
Please,
side,
please, I will.
then mention because there is an IFR vacating. Yes. 40? Yes.
47. Pratik.
Appearing for?
Appellant.
Why it is posted today?
Vacating interim order.
The request of counsel for the appellant leaves this matter next week.
Page number 30, serial number 53 to 61.
Serial number 55,
Hmm.
going to respondent.
Tyagaraja B.
Take 2 weeks time, council has been informed. Council.
Yes, at the request of township for the respondent, leave this matter after 2 weeks.
61 Mehta Ramazan.
Submitted and so on, so TCR, paper book, ಏನು post
Final
ಆಗಿದೆ?
hearing, sir.
Final year, yes, at the request of council for the applying, leave this matter of 2 weeks.
60 Pratibal Patil.
Yes, at the request of council for the applying, leave this matter of 2 weeks.
Page number 14, serial number 62 to 67.
Yes.
B. Shivakumar.
You are appearing for Shivkumar? Yes. Yes, at the request of council for the applying, leave this matter of 2 weeks. 64, yes, Mr. But. At the request of council for the applying, leave this matter 2 weeks.
Ajay Nayak.
Yes, at the request of council for the applying, leave this matter next week.
Page number 15, serial number 68 to 70.
You are appearing for?
B. N. Nagareddy.
Yes, at the request of council for the applying next week.
Page number 16, 71 to 73.
72.
Yes.
Paper for the respondent. To the other side.
C. Prakash.
At the request of council for the respondent, leave this matter of 2 weeks. 71.
B. Shivakumar.
Why? At the request of council for the appellant, leave this matter of 2 weeks.
Page number 17.
Serial number 74, your lordship.
Yes.
They appear for the respondent. I have informed the appellant councillor.
Go to the-
Senior sister has been expired.
Yes.
Senior sister has been expired. Today is the funeral.
You are
C.
appearing for?
Shankar Reddy.
I am informed, your lordship.
No, you are for appellant or
Respondent.
the request of
The board
council for the respondent. Leave this matter of 2 weeks. Yes.
Obliged, your lordship.
51, my lord. I informed. Kindly grant to
Serial number?
51. Yeah, please.
Inform ಮಾಡಿದ್ರ ಅವರಿಗೆ.
Yes, just inform.
You have, yes, at the request of council for appellant, leave this matter next week. Not granted earlier is extended till next date of hearing. Yes.
2019, I am not so legibly written in 2019.
Yes. First matter. Yes. Kumar. Yes.
Number 1 for dismissal. Serial number 1, Adi Narayana for appellant, Guru Prasad R.
Also.
There is a copy subjection, tactile matter. Serial number 2, Indra essay.
Also.
What is the copy subjection? Serial number 3, Narayana Rao HR.
Yes.
Stick code. We have filed it before this all. The valuation is below.
Want to withdraw that with liberty?
With liberty to file fresh appeal before to.
Yes, learned counsel for the appellant has filed a memo taking leave of this court to withdraw this appeal with liberty to approach appropriate legal forum. Memo is taken on record. The above appeal is dismissed as withdrawn with liberty to approach appropriate legal forum. You have to explain by filing an application.
Serial number 4, Sampath Anand Shetty for appellant.
Yes, Sampath Anand Shetty. Also,
Serial number 5, 6, 7 hundred. Serial number 8 hundred. Serial number 9, yes, Ganesh Reddy for appellant.
yes. Week's time is granted. At the request, week's time is granted to comply the task subject.
65 marks subjection. Serial number 10, Vijay Lakshmi HD for appellant.
Also,
Order serial number 11, M. Srinivasan for appellant, FP Lakshmi.
Dismissal of the appeal by the order non-compliance.
I went for one more thing.
ಏನಕ್ಕೆ YA 1/20? Learned counsel for respondent submits that respondent will not press IA 1/20. It's dismissed for not pressed. Three. Officer objection ಇದೆ. IA 1/20 ಅವ್ರದ್ದು ಅದು
ಅಷ್ಟೇ ಇನ್ನೇನು
objection
ಇಲ್ಲ ಸರ್ ಮ್ಯಾಟರ್ ಅಡ್ಮಿಟ್ ಆಗಿದೆ.
admit ಆಗಿದೆ. What is this? You are the plaintiff or a defendant? It is dismissed. You are in the possession of the property.
ಅಡ್ಮಿಟ್ ಆಗಿದೆ.
In spite of granting a sufficient opportunity, the paper book is not filed. Even when the matter is posted on 10/1/2024, appear for the appellant. Counsel for the respondent as present. Directed to be posted today. But the caption for dismissal and list for under order for dismissal of the appeal. Office is directed to post this matter today under order for dismissal of the appeal. Even today, when the matter is called, then appear for the appellant. Counsel for the respondent is present. It appears that appellant is not interested in prosecuting the case. Is dismissed for non-prosecution.
Serial number 12. Taxing for appellant. Fourth time office objection.
ಇನ್ನೇನು ಇಲ್ಲ.
Why yesterday you were not present? Senior is not there, you are there, why you are not present, Mr.? Yes. The request finally granted to comply that of subject.
Number 30, Naveed Ahmad for appellant, Papagouda B. Number 30.
Non-furnishing of PF, yes, week's time is granted to do the needful.
Number 40, Virupaksha PH for appellant, Jagadish N. Badiga.
Son has a legal. Residing in mother and the sister.
Furnishing of PF issue notice to that R1A. Respondent number 1 is dead.
Already on record. They are residing in the same address.
No, that Ramur Ramana Shetty is dead.
His wife and daughter responded already in record.
Who is R1?
R1A is his son.
Hmm.
Son is along with the mother,
Hmm.
but he has not received the notice.
ಏನಂತ ಬಂದಿದೆ?
The address ಸರಿ ಇಲ್ಲ ಅಂತ ಹೇಳಿ.
Then you take hands-on.
ಅವ್ರ ತಾಯಿ ಇದ್ದಾರೆ, ಜೊತೆನೇ ಇದ್ದಾರೆ ಅವರು.
How can I believe me?
Address correct ಇಲ್ಲ ಅಂತ ಹೇಳಿ ಬಂದಿದೆ.
Mati, what is the procedure? If address is not correct, you have to furnish the correct address.
Mother already has intentionally avoided. They are advocate ಮುಖಾಂತರ ಹಾಕ್ಬೋದು ಅದಕ್ಕೆ. ಯಾಕಂದ್ರೆ ಅವ್ರ ತಾಯಿ ಮತ್ತೆ ಅವರ ಸಿಸ್ಟರ್ ಇದ್ದಾರೆ ಆಲ್ರೆಡಿ ರೆಕಾರ್ಡ್. ಅವ್ರ ತಮ್ಮನ್ನ ಬಿಟ್ಟಿದ್ದಾರೆ, ಅವಾಗ ರೆಕಾರ್ಡ್ ತಂದಿಲ್ಲ ಅವರು. ಈಗ ನಾವು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ವಿ, ಅದ್ ಅಡ್ರೆಸ್ ಸರಿ ಇಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ, ಅದಕ್ಕೆ ಪೇಪರ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದೀವಿ, ಅದೇ ಅಡ್ರೆಸ್ ಅಲ್ಲಿ ಇದ್ದಾರೆ. ಮದರ್ ಇದ್ದಾರೆ ಪಾರ್ಟಿ.
Paper publication ಹಾಕಿದೀರಾ? Non-compliance of office objection raised on IA. You comply that. What is that in office objection?
He is notified for subjection. Notice not completed in respect of R1A and said. Notice not completed in respect of.
Outside notice not completed. IA 1 of 2024 is filed for permission to take out notice that respondent number 1A to paper publication in Kannada Prabha daily newspaper. There is that affidavit for the reason stated in the accompanying affidavit. IA 1 of 2024 is allowed. Senate counsel for the appellant is permitted to take out notice to legal representative of R1 to paper publication in Kannada daily newspaper. ಯಾವ ಎಡಿಷನ್ ರೀ? ಬ್ಯಾಂಗ್ಳೂರ? Bangalore edition on or before
8th February,
hearing date
7th March. Serial number 50, Sunil S. Rao for appellant, Jayalakshmi KB.
Non-compliance of office objection raised on 6 of 2023. Condemnation of delay in filing IA, setting aside abatement. Who has filed this application?
We have filed it for the appealing.
Hmm.
Not, sir, the original decree was, the original suit was for declaration.
What is that delay? We'll see that delay. No, what is that
Clarification.
office objection on that IA?
That has been overruled minutes of the last occasion and it has been allowed also if I am not wrong, but they said we wanted to file objections. That all those things have been overruled.
At the request of the learned counsel for the respondent, release this matter 11/1/24 ಅಷ್ಟೇ. ಏನು ಆರ್ಡರ್ ಆಗಿಲ್ಲ.
Can the one, not literally, it is a formal application seeking insofar as bringing the legal representatives of the original plaintiff appellant on record. Not the.
No, that you have to bring.
That can rectify the mistakes and the applications.
And Lord, on 26, there has been an order on IA 6, 7 and 8.
When
The Kumar's order, Lord, allowing these applications, IA 6, 7 and 8.
application is for taking recalling the dismissal of 2 to 4, recall, yes. 2 to 4 has been allowed. That is for dismissal recalled. There is,
6, 7 and 8, if they have any formal objection.
no, first we have to comply that objection on the office objection.
minor objection is overruled and we can take it upon merit.
Show me that order sheet.
All right, again, our that is coming, maybe it does not, no problem.
No, that nobody is seeing that order sheet. Some persons is telling, you are, whatever he said.
No, no, I was there.
Yes.
There on that day.
Yes, this is what that I have seen from every day that, see, order sheet, now everything is available on. Nobody wants to see anything. Now that office shows that there is an objection on that IA. You complied, then we'll allow that. It is the IFR bringing LRs at the appellant. Yes, you complied. When do you want? Yes.
Now, date be fixed on the matter, there is some.
2 days time is granted to comply that office objection. Please this matter next week.
Same day next week or not?
Same day it will come. Yes.
16, Mahendra Kumar BD for appellant, V. Vishwanatha Shetty.
On furnishing of PF cover, issue notice to R5, R6, first time. You want to file a paper book? Week's time is granted to file a paper book.
Serial number 17, V. Kunjal for appellant, Hari Prasad N.
Non-compliance of the office objection, right?
Together. So the final defined on the I can comply with both of them together. That is it, one big time we will comply with.
Yes, week's time is granted to do the needful.
Serial number 80, Balaraj AC for appellant, SVT Parmeshwarappa.
Week's time is granted to do the needful.
Serial number 19, Basavarajappa DR for appellant. Serial number 19, Basavarajappa.
Mesreno,
How is the circulation?
appellant. Yes, you are appearing for Sridhar, you are not there. Yes. ಏನಾಗ್ಬೇಕು? Yes. At the request of Garnet, at the request of the 14 person has present submits that he has taken NOC from the council for the appellant and he wants to engage some other council. Hence he prays time. Please this matter of 2 weeks.
Serial number 20, K. Sridhar for appellant, B.S. Manjunath.
Mediation centric.
Yes, we'll send it. Yes, at the request of the parties. ಏನಿದು ಡಿಕ್ಲರೇಷನ್ ಸೂಟಾ? Yes. Yes. Both the parties, council for both the parties has requested to refer this matter to mediation. Yeah, Bangalore Mediation Center. Hence, refer this matter to Bangalore Mediation Center. Parties are directed to be appear. Yeah, ನಿಮಗೆ convenient ಹೇಳಿ.
Next week
On 18th. 22nd. Yes, 22nd before the Bangalore Mediation Center. Office is directed to send that records to Bangalore Mediation Center.
Serial number 21, P.M. Siddamalappa for appellant. Serial number 21.
Week's time is granted to do the needful.
Serial number 22, adjourn. Serial number 23, Govindra Jail for appellant, connected matter. Yes, sir. Kamal Charan.
Appellant in the main matter. The appellant in the main matter.
Which
My
matter?
appeal had at 23.
Yes.
The appellant in 23.
Yes.
My matter had been dismissed for non-compliance of office objections.
Mhm.
Subsequently, I had complied with the office objections and filed an application which came to be allowed. I may be given a week's time to verify what. is the
After that also you have not complied.
I had complied with it, and based on that, the order was recalled. The dismissal was recalled.
ಮತ್ತೇನ್ರಿ non-compliance?
Provision before trial court to be stated.
ಕೈ ಹೆಂಗ್ recall ಮಾಡೋದು? ಕೊಡು. ಅದಕ್ಕೆ. Accepting the reasons stated in the complaint, accompanying application is allowed. Where is that? You have not complied that office objection.
My lord, it's a subsequent objection raised, court fee provision.
Earlier
Deficit
it was
court fee
not
had-
there.
Earlier it was not there. Deficit court fee had already been paid.
Subsequent. In a more days.
Yes. How many?
A week's time. And
Yes.
For the second, if I may kindly serve a copy upon my learned.
Yes,
friend.
yes. At the request of learned counsel for the appellant, first matter, week's time is granted to do the needful. What about that second matter? You have to file a paper book. Yes, second matter, 2 weeks time is granted to file a paper book. Yes.
Much.
Bill number 24, Shivakumar V for appellant. Bill number 24, Shivakumar.
On publishing a PF cover acknowledgement address issue notice to the respondent posted for that. It is early hearing filed by the advocate of the appellant is written with yes. Week's time is granted to do the needful.
Bill number 25, Cyril Prasad Pai for appellant.
April, please, time to comply.
Yes, at the request, week's time is granted to comply the top subjection.
Bill number 26, Abhishek Appandi for appellant. Devoya Ayam.
Accepting service of court notice, appellant endorsed as a subject. Yes.
This is arising out of civil defamation.
Yes.
Where the appellant was ordered to pay damages permanent injunctions. In a public apology.
Hmm.
Similarly, there was a criminal defamation also,
Hmm.
in which he was criminally convicted.
Hmm.
Then in that appeal in the criminal matter,
Hmm.
which was going side by side with this matter. At that time, this matter had filing number here. He unconditionally apologized to the appellant here and the appellant in that case.
Yes.
Sorry, to the respondent here. Sorry.
Yes.
So then your honor, there was a joint memo recorded in that matter on 9/12 of 2019.
Hmm.
And then subsequently, the joint memo was taken to the local Adalat here. And so the joint memo in this video, the same thing was filed before this court on 15/6/2020. So filing our objection, because he had apologized there, we filed this, all these documents on record, including the order sheet and the joint memo from there here.
Hmm.
In the page 6 here on, this is in the criminal appeal 1381 of 2019. As we go down, it said, you know, when they're addressing also the civil matter, because the apologies can be forget there.
Yes.
The in view of the opposite, I'll start from the beginning. The appellant and the respondent with the intervention of the elders and well-wishers. The appellant has unconditionally apologized and the same has been accepted by the respondent. In view of the above apology, they are willing to withdraw the allegations made against each other. In view of the aforesaid compromise, the aforesaid appeal, in this context, the aforesaid appeal is the criminal appeal,
Hmm.
may be allowed and the accused may be acquitted because of the apology. So we did not insist on punishment, Your Honor. Then, Your Honor, further the respondent has filed a suit for damages in OS number 290/4/2009 against the appellant before the Honorable City Civil Board. And the same was decreed on 11/9/2019 against the appellant. The criminal thing also is the appellant. The above said decree may be set aside. Now, because we are not insisting on the damages in public apology in light of the thing. Against the judgment, the appellant has preferred an appeal in RFA number 2520 of 2019. That is the filing number for this case, Your Honor.
Yes.
At that stage, it was the filing number.
Yes.
Which is pending before the Honorable High Court of Karnataka. The same may be set aside and appeal may be allowed in terms of the joint meeting. So, in light of this prayer, Your Honor, that the matter was referred to the local Adalat, it is our humble submission that this appeal may be disposed in accordance with the joint.
Yeah.
My lords, 1 week time
Will-
may be given, my lords. We have to seek instructions from our clients, my lords. And kindly have it in the next week, my lords.
No,
I'll seek
because
instructions.
matter has been settled.
Yes, my lords, we have not informed by our client. my- Hence, 1 week time may be given. my lords.
Yes, we'll have this matter, you are just to 11th, no? And 19th. No, 18th we will have this matter. You get instruction. You get instruction in view of that settlement. This has to be disposed of.
Otherwise, it is contempt also.
Let us see that
Yes,
they
sir.
have to
Yes.
take instruction from. Yes,
So, please.
yes, leave this matter on 18th at the request of parties.
Acceptance of court notice.
Number 27, P.B. Raju for appellant, K. Srinivasa.
Yes, week's time is granted to do the needful.
Serial number 28, Shadmukappa for appellant, government advocate.
Yeah, copy. Yeah, no, yeah, 1 of 2023.
To bring enlargement of this is the appellant.
Appellant number 1, yeah. Yes, who is that other side?
Government advocate.
Yes, we'll allow that application to bring LRs of the appellant. Yeah. ಯಾರು ಸತ್ತೋಗಿರೋದ್ರಿ?
My lord, appellant number 1A, that is Krishnappa, my lord. Sri
One
Krishnappa.
A is there, huh?
Yes.
Yes. Yeah. 1 of 2023 is filed for bringing LRs of. This is appellant number 1A. Where is that affidavit? For the reason stated in the accompanying affidavit. Yeah, delay anillala. Yeah, 1 of 2023 is allowed. Loss of deceased appellant number 1A is permitted to come on record. Learned counsel for the appellant is permitted to amend the cost title. Yes. Amend ಮಾಡಿ.
Serial number 29, H.R. Ananta Krishnamurthy.
Permission filing of paper book. Finally, 4 weeks for the request is granted to file a paper book.
Serial number 30. Sandeep Lahiri.
Quantitatively, I'm not kidding. 2 lakhs get from the
Now that who is appearing for other side?
Satisfied fully has paid the money. As regards to refusal of my setup as my disbursement, it is restricted to the setup which is disallowed.
Now that
There is no state.
you are the defendant, suit for recovery. What is that degree?
1,63,000 which have already paid, the entire amount has been paid in principal.
Now you have claimed that setup for 2 lakhs. That has been rejected. Further declare that defendant with interest. It is 40,000 so and so. The entire digital amount. Pay to pay the digital amount so and so. Yes, where is that finding?
Para 18, page 42, I think, it's regarding my contention, but the next page, this judgment is also relied. Here are the pleadings of the plaintiff and also it's one appear to plead.
binding court. In this case on hand, the defendant is utterly tentatively quantified with rupees 2 lakhs, then defendant has to provide particulars of cross cost to him, which could be ascertained and tentatively loss of rupees 2 lakhs. Therefore, when there is no yardstick to quantify the amount of settlement there, he utterly failed to prove this under this setup has been rejected on the ground that quantification could be done. So the amount has also not been done. Now, I am talking of this particular aspect of the finding and find this appeal. Now, if this honorable court comes to the conclusion that I am entitled for any setup, whatever the amount that is granted, other mere court fee, I am undertaking also that I pay the court fee. But at this stage, your court fee is not applicable. I have explained this was registered in the matter was posted. The honorable registrar and submitted the judgment also. I think.
Now, suppose if your appeal is dismissed here after hearing, you don't want to pay any court fee. Your appeal has been heard the free service.
I understand that section 49 of the court fee supervision mandates whatever is the court fee I'm entitled, I'm liable to pay before the court of first instance. That is the court fee that I'm liable to pay. Because as per the law, if I'm not liable to pay any court fee for claiming equitable set of bills, under section 49, same law will prevail. Because the kindly see for a minute, it's categorical finding either issue whether it is not to I have produced the Messrs. ILR 1998 and 745. Final judgment of this on 1990 Karnataka.
Where is that copy?
If the laws permit, can I give my copy? Same issue, the question of equitable set of million, honorable court also gave the same fine.
Hold that the mere facts of reading set off in the 4 lakhs defense doesn't become liable to pay the court fee. The liability will be arises only after the court ascertains the term in the context of the claim made by them, who thereafter has to call upon the court to enforce the benefit of the claim. The matter currently the defendant did not carry with the liability to pay the court fee since direction made by the court below to pay. Respect of office objection. Learned counsel for appellant has relied on judgment of this court in ILR 1990 Karnataka 745. Mrs. Anand Enterprises versus Syndicate Bank contended that since he sought for a setup, same has not been determined, he need not pay court fee. Payment of court fee arises only after the determination of setup, and he has not paid any court fee before the trial court. Submission is taken on record. Office objection is kept open. Issue notice.
And wait.
We'll see that. Yes.
As for the finding,
Yes. Yes.
and wait.
Bill number 31, Baswarajappa DR for appellant.
What is time run out?
Appeal copy ಕೊಟ್ಟಿಲ್ಲ ಅವ್ರಿಗೆ ಕೊಡಿ. Yes. The request 4 weeks time is granted to file a paper book.
Bill number 32, Tripurti KP for appellant, connected matter, Harish NR.
You are appearing for furnishing of PF issue correct notice to R2.
ಇದರಲ್ಲಿ ಮೊನ್ನೆ R2 ಬಂದು ಒಕ್ಕಲ ಹಾಕಿಲ್ಲ. He undertook to file power on Monday. And
ಯಾರು?
R2.
Who has undertook?
He is the dependent.
Huh?
He is appellant in the appeal RFP 183.
Harish NR.
Harish NR is the appellant. Who is R2? What is the name of R2?
Timam.
Timamma. Who is the appellant in the connected matter? Timamma. Then Harish NR will take notice. Where is he? Yes, Harish.
Monday itself, I have filed vakalat. Same is
Yes,
not put up.
Harish NR submits that he has filed an power for respondent number 2. The office is directed to show his name for R2. Alig nimdu process complete ಆಯ್ತು first matter. What about the second matter?
I am the appellant.
Steps to be taken for unclaimed R2. Who is R2?
R2 is appellant in this matter, RF 95.
Well, then- Ramu, you will take notice. Yes.
As far as this appeal
Sri.
is concerned,
Vibhuti KP undertake to appear for respondent number 2, 32.1. Office is directed to show his name. Yes. Post this.
as far as RF 95 is concerned, it's not for stable.
Wait.
Classification.
Hmm.
I have not received any, when it has come on record, the second placement is
What is that money? It's suit for injunction.
mandatory.
Hmm.
Terminal benefits of the father.
Hmm.
21,30,000 was paid to the mother.
Hmm.
Since she was an offender.
Hmm.
Even in the record, it has come that the mother has received money.
Hmm.
But the decree against both
No, you are the plaintiff or a defendant.
and defendant number 2 is.
Who is the plaintiff?
I am the plaintiff in the.
You are the plaintiff. Yes, so
My grievance is, my share has not paid. My share of 1/3 share is not paid.
1/3 share of what?
Out of the death benefits of PD Govindraj, who is an employee in the BMTC.
Govindraju. You are the,
Govindraj is wife of Timam.
no, you are the son of Govindraju.
Govindraj,
Who is, Timamma is the wife.
wife.
Who is Ramu?
Ramu is also one of the son,
Son.
elder son.
Managing director so and so. Alige Lakshmamma, Timamma, G. Ramu. ಅಂದ್ರೆ ಎಲ್ಲರಿಗೂ 1/3 ಬರಬೇಕು.
Is the-
What is that degree passed by the trial
That is
court?
the decree passed.
Huh?
That is the order passed by the trial court.
Hmm.
Operative portion is at page number.
1/3 share, that benefit to
Page
be
number
received
24.
belongs to that. Yes, what is your grievance to challenge that appeal?
Already mother has received 21,30,000 from respondents 3 and 4.
Hmm.
Employee in the ISCO material.
Hmm.
Now the direction is second paragraph. Both defendants 1 and 2, 1/3 money command. I have not received the money.
No, now that entire amount, what is that total amount?
21 lakhs, 21,30,000.
21 lakhs ಕೊಟ್ಬಿಟ್ಟಿದ್ದಾರಾ?
41 lakhs, 30,000
ಇನ್ನು ಬರೋದಿದೆ
is only a provident
ಇನ್ನು
fund.
ಬರೋದಿದೆ ಅಂದ್ರೆ that is.
That is different. Now 21 lakhs has been paid to whom?
Mother.
Who is appearing for mother?
I appear.
You have received 21 lakhs.
Please, madam.
Hmm.
Well, my contention before the trial court is, after receipt of the amount,
Hmm.
I have discharged the loan borrowed by my husband.
Hmm.
This is my stand before the trial court. Madam. Well, the plaintiff has sought for the injunction, bare injunction.
Hmm.
The suit itself is not maintainable. But the suit is for mandatory injunction to direction to pay it. Instead of money recovery suit, instead of filing money recovery suit, they have filed a mandatory injunction. But the suit is not maintainable on this point.
No, that will see later. Now that trial court has declared that they are entitled 1/3. See that 1/3 share of that defendant has to be kept intact. You should not utilize enter tomorrow if this court held that yes, he is entitled 1/3.
That money is already paid. Malady, before filing this suit itself, the money has been paid to mother.
Now that-
Paid to me.
See, plaintiff is entitled to get 1/3 share of 21. Defendant number 1 and 2. Your case is that you have not taken any money. Yes. Will grant stay only in respect of you are the defendant number 1. Defendant number 2. Yes. What is your appeal, Mr.?
My appeal is, my lord, the suit itself is not maintainable.
That we'll see that later.
That amount has been, my lord, I have discharged the loan of my husband.
Hmm.
Amount kuda ನನ್ನ ಹತ್ರ ಇಲ್ಲ ಈಗ ನಾನು discharge ಮಾಡಿದ್ದೆ. Even, my lord, I was made as a nominee in the service record. Therefore, my lord, amount, I am entitled for entire amount.
No, therefore, what is the law on that point?
My lord, nominee,
Whether nominee alone is entitled for entire retirement benefit or that legal heirs has any right over the property. You have to establish. That's what, yes, last occasion also I told.
nominee,
Nobody-
general,
Nominee is only entitled to receive the amount, but Right of share will not take up. That is the,
Give me that.
please, my lord, kindly see the page number 12. It is the observation of the trial court. I have placed the judgment based on that.
Where is that? Give me that judgment, Mr. Let me see also.
That
Why
is
are
in-
you hiding the judgment?
That is
Is
in
it in a
general
public
principle.
document?
That is in general principle. Insofar as service rules is concerned, my lord, I was in service record, I was made as a nominee.
I three, the Kodre one authority, everybody is arguing on the air, Mister. Give that authority or that law, service law, Torsi. It is only all benefit has to go to that only that nominees. Where is the judgment? It's a court of law, whether you have to decide in accordance with law or that what you have said have to be recorded. This is all that in respect of the LIC policy and all. Where is that law, Mister, on service law?
Point.
No matter.
But the suit maintainable, kindly, two sentences.
I agree, Adalla Nodanri, all point has to be, first you answer my point, you will see that. If you are entitled for everything as a nominee, then question of whether suit is maintainable or not, then suit has to be dismissed. If you say that, no, all are entitled as a legal representative, then we have to see whether suit is maintainable or not. Is it not?
The only contention before the trial court is that I am the nominee, I am entitled for receiving the. Now, what they have said is submitting before this.
No, if he proves
They have
that,
cleared the entire loan. It is not so.
Yeah,
clear.
that-
Loan has been cleared by the,
I tapan you first question.
Yes.
please,
You
my
have to answer that question regarding that maintainability, not maintainability on the law, whether you are alone is entitled or suit is done.
lord.
Is it not?
LIC matter.
Hmm.
The question of, this question has arose, therefore court has held that.
No,
nominee-
LIC, LIC is not in a,
La-
retirement
Subject matter
benefit.
is pertains to LIC.
Hmm.
Receiving of death benefits is question, that is the question. Nominee is entitled to receive the amount. That is what the.
No, LIC law, that is the rule, Mister. You have to show in that service law.
Even in the banking
that will-
regulations, nominee is entitled to receive the amount. But the right of share will not take away that nomination.
So ಏನಿದೆ ಎಲ್ಲಿದೆ ಕೊಡಪ್ಪ?
I will place it.
That's what you ಅಲ್ರಿ
Please,
ಅಷ್ಟೇ ಹೇಳ್ಬೇಕು ಆಯ್ತು ಸ್ವಾಮಿ ನಾನು ಅದನ್ನ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತೀನಿ
please,
ಸುಮ್ಮನೆ
please, my lord.
ಏನೋ ಪಂಚಾಯತ್ ಮಾತಾಡ್ದಾಗ ಮಾತಾಡ್ತೀರ ಆರ್ ಯು ಆಲ್ ಬಿಫೋರ್ ದ ಕೋರ್ಟ್ ಆರ್ ವಾಟ್ ಮಿಸ್ಟರ್ ವೈ ಆರ್ ವೇಸ್ಟಿಂಗ್ ದ ಕೋರ್ಟ್ ಟೈಮ್ ಜಸ್ಟ್ ಯು ಹ್ಯಾವ್ ಟು ಶೋ ದಟ್ ಲಾ ಅಂಡ್ ದ ಜಡ್ಜ್ಮೆಂಟ್ ಹ್ಯಾಸ್ ಟು ಕ್ಲೋಸ್ ದಟ್ yes now that have they filed an execution yes how to notice ಆಗಿದೆಯಾ yes day of judgment and degree dated 28th October 2021 passed by the second additional city civil and section judge Bangalore in OS number 2472 of 2019 in respect of appellant defendant number 2 till next date of hearing.
PF ಬಂದಿದೆ ಮ್ಯಾಟ್ರ್ ಎರಡು ಅಡ್ಮಿಟ್ ಆಗಿದೆ ಅಪ್ಲಿಕೇಶನ್
Application ಇಲ್ವಾ ಇದ್ರಲ್ಲಿ? ಇವ್ರಲ್ಲಿ have they not filed any application for stay?
ಇದೆ ಸರ್ 1/22 ಅದ್ರ ಮೇಲೆ ಏನಾಗಿದೆ
Yes.
RFL 85.
Yes.
ನಾ 22
Yes.
ಮಕ್ಕಳಲ್ಲೂ ಸ್ಟೇ ಅಪ್ಲಿಕೇಶನ್ ಇದೆ ಅದರಲ್ಲಿ
ಹ್ಮ್.
ನಾವು ಅಮೌಂಟ್ ಅನ್ನ ಲೋನ್ ಡಿಸ್ಚಾರ್ಜ್ ಮಾಡೋದಕ್ಕೆ ಮೆಡಿಕಲ್ ಎಕ್ಸ್ಪೆನ್ಸಸ್ ಗೆ ಸ್ಪೆಂಡ್ ಮಾಡಿದ್ದೀವಿ.
ಹ್ಮ್.
ನಾವು ನಮ್ಗಿನ್ ಪರ್ಸನಲ್ ಎಕ್ಸ್ಪೆನ್ಸ್ ಇರೋದಿಲ್ಲ. ನಾವು ಆಸ್ ಅ ಬೀಯಿಂಗ್ ಎ ಮದರ್
ಆಯ್ತು ಎಷ್ಟು ಲೋನ್ ಇತ್ತು?
ಅದು ಕ್ವಾಂಟಿಫಿಕೇಶನ್ ಏನು ಬಂದಿಲ್ಲ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ರೆಕಾರ್ಡ್.
ಆಯ್ತು at least you keep that 1/3 share of that plaintiff. You are not directed him to release him also, but keep it 1/3 in that executing court. Or before this court, you deposit 1/3. Then we will see whether other share is concerned. There is no dispute here. Here only the plaintiff before the court. He says, I want 1/3 share. There is an order. You keep one third share before this court. I will stay this order.
Next I will submit my next date of hearing.
Yes, release this matter next week. Yes.
Step number 33, Srinivas B for appellant, Vijay Kumar T.
Respondent number 1 is LS Mailar, ಅದಕ್ಕೆ ಇವತ್ತು ಮೆಮೊ ಆಗ್ತಾ ಇದೆ.
Steps to be taken for deceased R1, return unserved cover with posted Sara. Yes, R1 is dead. What you want now?
ಮೆಮೊ ಆಗ್ತಾ ಇದೆ. R1 is LS Mailar, ಅದಕ್ಕೆ ಇವತ್ತು ಮೆಮೊ ಆಗ್ತಾ ಇದೆ.
Who is this LRs? They are already. Alternate counsel for the appellant has filed a memo stating that the respondent number 1 is dead. Leaving behind respondent number 2. Who are that, Mr. 2? 2 to 5 are the LRs of deceased respondent number 1. Memo is taken on record. Respondent number 2 to 5 are treated as LRs of deceased respondent number 1. Learned counsel for the appellant is permitted to amend the cost rate.
Number 34, Prasanna Kumar CS for appellant, Ramu.
Appellant, sir, 2 weeks time to take out step to unserved response irritated to.
Notice issued to that respondent number 3 and 20. Return with postal shara unclaimed. In service of notice to R3 and 20 is held sufficient. 12 and 21. 8.
21 to 23, the cover has not been received by the office. 8 and 12 has been returned. 8 has been returned with insufficient address. And 12 has been returned without the postal shara. I will take out steps again.
Yes.
8 and 12.
I'm undertaking to file as
12 and 13. Huh? Oh, what's your name?
MV.
MV? Vishwanath. Learned counsel is undertake to appear for respondent number 12 and 13. Week time is granted to pay the process, issue notice to other unserved respondent. Yes.
Number 35, 7 is appellant.
Yes.
Office objection has been complied with the memo filed during compliance also.
Yes.
The detailed memo for valuation along with guidance copy as per guidance value has been filed. All the details for this show that the jurisdiction for the purpose of jurisdiction 8,02,800 is valued. Mentioned also in this.
What is the suit for?
Partition.
Suit for partition.
Partition.
What is that valuation made in the trial court?
They have not made the valuation.
Now you have filed. Where is that?
Now I have filed the certified copy, the guidance copy as on the date of suit.
Where is that?
Sorry, not the file is with the colleague, his legs in another court.
Password.
I'm just clarifying, my lord, because the office has noted the office details.
No, where is that? Whether it is an IA, it is a memo.
No, it is a memo, my lord.
Yes, password, you verify. Yes.
Number 36, Manjunath A for appellant.
Office note says appeal is valid more than 15 lakhs. Hence post this matter before the division bench having in a roster.
Number 37, Harish NR for appellant. Exceeding 50 lakhs.
Office notes says the value of the appeal is exceeding 15 lakhs. Post this matter before the division bench having in a roster.
Serial number 38, Sridhar AG for appellant.
My lord, 1 week time. My lord, ಇದರಲ್ಲಿ execution ಹಾಕೊಂಡಿದ್ದಾರೆ ಮೇಡಮ್. So ಅವ್ರಿಗೆ 240 feet ಅವ್ರಿಗೆ ಅಲಾಟ್ ಆಗಿತ್ತು. So execution ಹಾಕೊಂಡಿದ್ದಾರೆ ಬಟ್ till date ತನಕ ಒಂದು ಸ್ಟೇ ಕೊಟ್ರೆ.
You serve a copy to that counsel who is appearing in that
execution ಅವ್ರಿಗೊಂದು ಫೈಲ್ ಕೊಡ್ತೀವಿ ಸ್ವಾಮಿ.
Why you have not furnished that PF?
Compliant.
Yes, week's time is granted to do the needful.
Permit to execution.
In addition, the appellant is permitted to serve a copies. Counsel appearing for the respondent in the executing court. Yes.
Number 39, Vinatilian for appellant.
For what? Yes. Finally, 2 weeks time is granted to file a paper book. Entry matter granted earlier, if any, is extended till next date of hearing.
Party, Karnataka appellant Vijay Kumar K.
Yes,
Two weeks time.
yes, 2 weeks time.
Article and file local for article next date of the.
No, that's. Notice is not at order.
Therefore, I will.
Awaiting service or notice ಆಗಿದೆಯಾ? You are taking notice to whom?
Article,
Yes. R12 ಇದರ?
article is there.
R 1 to 7 ಅಂತ ತೋರಿಸಿದಾರೆ?
See, there are 13 respondents are there.
Notice should be issued all these other things.
ಅಲ್ಲ, but awaiting only 1 to 7 ಅಂತಿದೆಯಲ್ಲ, ಏನದು?
Remaining rest of the respondents, 9 to 11 and last date of the required, I need to, because I paid 2 caveats. Now article also I need to pay local. Only for.
Notice should go to all the parties.
No, Vijay Kumar appearing for
Gavator, respond number 10 is.
9.
9.
Hmm.
And 10 and 11 also.
10 and 11 also will take notice.
Yes, will.
Yes.
10 to 12 day I will pay local.
Notice.
Now that 9, you have taken 9 to 12, you will represent.
Yes.
What about 13?
Bank notice has to go.
Notice order ಮಾಡಿಲ್ವಾ?
ಇಲ್ಲ.
Why that notice is not ordered?
By mistake, it might have not been.
Filed on a memo seeking.
R8
memo
also
expression
date, therefore
accordingly
they need to take
dismissed as
steps.
not trust. Karnataka Council.
Last occasion, death of R8 was reported, Malaysia.
Council appellant is granted to 4 weeks time to take next issue emergent notice to unserved respondent. Unserved respondent ಅಂತ ಇದೆಯಲ್ಲ?
That's why. Notice.
Yes. 9 to 11 ನೀವು ಹೇಳಿದಿರಲ್ಲ, ಯಾಕ್ರಿ ಅವ್ರ ಹೆಸರು ತೋರಿಸಿದಿಲ್ಲ? ವಿಜಯ್ ಕುಮಾರ್ ಫಾರ್ R1.
ವಕಾಲತ್ ಹಾಕಿಲ್ಲ ಅವರು, ಅಂಡರ್ಟೇಕ್ ಮಾಡ್ಕೊಂಡು.
ಎಲ್ಲಿ ತೋರಿಸಿದಾರ್ರಿ?
Gavator 9 and 10 and 11. ಎರಡನೇ ಲೈನ್.
The notice not ordered ಅಂತಿದೆ.
Page 37 ಅಲ್ಲಿ ಕೇವೆಟ್ ನಂಬರ್ ಅದು. 10 and 11 ಇದೆಯಲ್ಲ ನೀವು?
11 will also.
12 also will take. Yes. Shri Vijay Kumar
9 to 12 Vijay.
further undertake that he will also appear for respondent number 12. Office is directed to show his name.
Regarding respondent number 8, I have to take steps to LR Smallers.
Yes.
Last occasion, our death was reported.
Service to notice R1 to 7 is awaiting. Issue emergent notice to
13 also.
R13. Then what is that office objection?
Second time they have raised, I don't know that. I will verify.
Yes.
2
2
weeks.
weeks time is granted to comply that office objection. Yes.
IO granted me.
Interim order granted earlier is extended till next date of hearing.
Much obliged.
Party one document as per appellant.
For the applied matter.
Hmm.
In fact, with respect to the off subjection, which is right,
Hmm.
the notice also prefer the issue is the institute for partition. I appear for the respondent, defendant number 3. I also sought for partition of one another property in that.
Hmm.
The plaintiff did not value the plaint. I have produced the valuation slip also along with the appeal memorandum.
Hmm.
May I request your lordship to kindly come to page 64, my lord.
Hmm.
The plaintiff there, while filing the suit, has not valued the property.
Hmm.
Now the office wants me to evaluate, which is not possible.
No,
As-
not possible, Allah. What is the market value of the property? Now we have to.
ಅಲ್ಲ, ಇವಾಗಿನ ಲೆಕ್ಕ ಬರುದಿಲ್ಲ ಅದು.
ಇವಾಗಲ್ಲ, ಅವತ್ತಿಂದೇ ಮಾರ್ಕೆಟ್ ವ್ಯಾಲ್ಯೂ ಏನಂತ ಪ್ಲೇಸ್ ಮಾಡ್ಬೇಕು. ಯಾಕಂತಂದ್ರೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಸಿವಿಲ್ ಜಡ್ಜ್ ಮುಂದೆ ಹಾಕ್ಬೇಕಾದ್ರೆ ಅವರಿಗೆ ವ್ಯಾಲ್ಯೂಯೇಷನ್ ಎಷ್ಟಿದ್ರು ಪ್ರಶ್ನೆ ಇಲ್ಲ. ಇಲ್ಲಿ ಜುಡಿಸಿಕ್ಷನ್ ಪ್ರಶ್ನೆ ಬರುತ್ತೆ.
ಅಲ್ಲ, ಒಪ್ಕೊಂಡೆ.
Therefore, you have to produce that.
ಒಪ್ಕೊಂಡೆ. In fact, this matter was supposed to be before the division bench for the simple reason. ನಂದು ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಪ್ರಾಪರ್ಟಿ ಕೂಡ ಪಾರ್ಟಿಷನ್ ನಾನು ಕೇಳಿದ್ದೆ, ಅದು ಕೂಡ ವಜಾ ಆಗಿದೆ. ಅದರಿಂದ ಅದರಲ್ಲೇ ನಾನು 15 ಲಕ್ಷ ರೂಪಾಯಿ ಅಂತ ಬಿಟ್ಟು ನಾನು ಬರ್ದಾಕಿದ್ದೀನಿ ನನ್ನ ವ್ಯಾಲ್ಯೂಯೇಷನ್ ಸ್ಲಿಪ್ ಅಲ್ಲಿ. ಈ ಎರಡು ಸೇರ್ತು ಅಂತ ಹೇಳಿ suddenly go
That is
beyond.
what court wants to see in the valuation ಅಲ್ಲಿ. That market value is more than 15 lakhs ಅಂತ ಹಾಕಿದ್ರೆ ಅವ್ರು ಆಟೋಮೆಟಿಕ್ ಡಿವಿಷನ್ ಬೆಂಚ್ ಕಳಿಸ್ತಾರೆ.
ತಾವು ದಯಮಾಡಿ ಇದ್ರಲ್ಲಿ ಪುಟ 65 ನೋಡಿ ಸರ್, ನನ್ನ ವ್ಯಾಲ್ಯೂಯೇಷನ್ ಸ್ಲಿಪ್.
ಅದರಲ್ಲಿ 90 ಲಕ್ಷ ರೂಪಾಯಿ ತೋರಿಸ್ತೀನಿ ವ್ಯಾಲ್ಯೂಯೇಷನ್ ಆಫ್ ದಿ ಪ್ರಾಪರ್ಟಿ.
ಎಲ್ಲಿದೆ?
65 ವ್ಯಾಲ್ಯೂಯೇಷನ್ ಸ್ಲಿಪ್
65ರಲ್ಲಿ ಎಲ್ಲಿದೆ?
ಕಾಲಮ್ 2 ನಲ್ಲಿ
ಹ್ಮ್.
3 ನಲ್ಲಿ.
Appeal is filed for rejection of the counterclaim.
Yes, and as well as granting the partition beyond his entitlement.
Yes, learned counsel for the appellant has submitted that as per that valuation slip produced by the appellant, the counterclaim claimed by the appellant, the value of the property itself is mentioned as 90 lakhs.
ನನ್ನ ಶೇರ್ಗೆ 15 ಲಕ್ಷ ಬರುತ್ತೆ.
Yes, 19 lakhs. If the share of the appellant is comes more than 15 lakhs.
15 lakhs. 90 6 ಭಾಗ ಮಾಡೋದ್ರಿಂದ 15 ಲಕ್ಷ. 15
more than 15 lakhs. Submission of learned counsel for the appellant is taken on record. Since the value of the appeal is more than 15 lakhs, post this matter before the division bench having in a roster.
Application matters in number party to adjourn, in number party to Alesha RG for appellant. Yes, party.
Partition. With respect to item number 2, may not be decreed and paid. But the may not be with respect to item number. The year 2011. It is schedule item number 1. The may not be, it is dismissed fully on the contact may not, it is itself. It is not speculative capacity. With this passage of the same deed has taken place and in the year 2011, the schedule item number. The present appeal has been filed in the year 2016. The plaintiffs will not the fact of dismissal of. They have not they have prepared the decree stating that the item number 1 is also decreed and they have placed for the competent authority and year 2011 itself, I purchased, I have obtained the sanction plan license and I have done commercial and I am sitting there and rest of my lord I have let out the review of the tenants. Eight my lord, they are creating the nuisance.
How you want to inflate?
The respondent number 10.
Who is appearing for that this thing? Appellant. Yes, Pastor, you get him. Is there any objection? Let us see. Otherwise, we will allow that. Pastor. 44. Yes.
My lords, in this matter, I'll file the amended appeal memorandum. It was supposed to be listed for final hearing, but because I had not filed it, it's come up for this.
Yes.
It may be listed for final hearing. I'll do it in the course of the day, my lords.
Yes, learned counsel for the appellant. Pastor, you do it at 2.
Please, my lords, I'll 2:30. I'll.
Yes.
Much of.
Pastor.
Number 45, Vishwanath.
For the appellant. The settlement has been made. Also given an offer as well. So settlement negotiations are going on.
Yes. Yes. At the request of counsel for the parties. How many days time? How many days?
By next week, anytime next week.
Yes. Both the councils are submits that parties are negotiating for settlement.
Yeah, 28 minutes.
Is this matter on 22nd, 23rd?
Right.
Yes, 22nd.
Number 46, N pages for appellant, Y.K. Narayan Sharma.
The appellant notice, I paid the cost and filed the memo yesterday. Cost received.
You received the cost.
Yes, sir, file margin.
Yes, learned counsel for the appellant has submits that they have paid the cost of 2,000 to the respondent.
Respondent.
Yes, submission is taken on record. Yes, appeal is admitted. Now it has to post it for hearing.
It is admitted, but it may be
Appeal not admitted.
and then dispose about the admission stage because food for partition. Different number 2 is appeal. Different number 2 is the younger son. The properties belong to the mother. After demise of the mother, the khata was transferred into the name of defendant number 2, with no objection given by all the other family members. After obtaining NOC, he has put up 2 floors of construction on the suitable property and he was in possession, not in dispute. Now, the trial court held that Lord, I am not able to prove that I have constructed by investing 35 lakhs in the suitable property.
Now,
Lord, there is no dispute in the
who is the plaintiff?
plaintiff is one of brother.
Plaintiff is your brother.
Brother.
Your name is Harish.
Harish.
Who is defendant number 1? He is also your brother.
Brother, my lord. Defendant number 3 is sister.
Sister.
The
Now
sister
it's-
supports my contention to defendant number 3.
Now that it is not in dispute that it is in a joint family property.
It is not in dispute, my lord.
You
Because
are-
there is no partition among the family members. Now, the contention taken by the defendant number 2 in the written statement for trial court is that it is the wishes of her mother's wishes that the property should go to the younger son, because all other members, the brothers are settled and they have settled residing.
No, is it a law that she can say that?
That is the, no, I'm just, he
Nice.
has taken a contention.
Content, yes.
Apart from that, my lord, he has taken a contention that he has put up construction and that cost has not been
No,
taken
but
into
now
consideration.
what is that sources of income for you to construction and all?
No, that is also not in dispute that I'm running with a separate business. No dispute between parties. There is no joint family business. I'm doing my personal business out of my income. I am not in the evidence. They suggest that the only suggestion that I have put up construction without their consent. That's the only contention taken in the cross examination. In the written statement, rather than the plaint or other written
No,
statement,
it is only a site. There is no other.
house property. There is only a house property.
Now that you have constructed an
2-floor, my lord,
2-floor building,
that has not taken consideration.
what business you are doing?
Some chemical business, my lord,
Hmm.
is doing.
No, what is that cost of that construction?
Some 35 lakh rupees, my lord.
35
For
lakhs.
that, I have produced documents for payment having been made to the
No, that is
contractor.
true.
They are
Then-
not disputed and I have not constructed. They are only concerned that I have not taken any consent. My lord,
No, yes, Mr. You are not disputing that he has constructed.
No, there is a dispute because he says that he has taken loan for development of the property, and in the cross examination he has admitted that that loan has been taken for some other purpose. That is for defend number
No,
1.
whatever may be the things, it is in an open site.
No,
what is-
no, house has been constructed prior to itself.
ground floor ittu.
ಮನೆ
ತಂದೆ ತಾಯಿ
ಕಟ್ಟಿದ್ದಾರೆ,
ಇರ್ಬೇಕಿದೆ.
ಮನೆ ಕಟ್ಟಿದ್ದಾರೆ. ಆ-
Ground floor ಇತ್ತು. Ground floor ಅಲ್ಲಿ ಯಾರಿದ್ರು? When rent
ನಾನು ನಮ್ಮ mother.
there is no rent.
ಇಲ್ಲ ಇಲ್ಲ.
There
ನಾವೇ
is no
reside ಆಗಿದ್ದು.
income from that property.
ಇಲ್ಲ separate income business ಇದೆ. No
Wait,
dispute.
Mr. Counsel, there is no income from that property, is it not?
Yes, yes.
Then how you can be constructed that property with the,
All the family members have give money for that, my lord.
no,
That's
now
the case.
is it your case that all are contributed for construction?
Yes, yes.
Now, where is that pleading?
1 minute.
Show me that. It should be in your client.
Yes, yes.
Yes. Yes. Paper book ಹಾಕಿದೀರಾ?
ಇಲ್ಲ ಇನ್ನೊಂದು.
Yes. Post this matter for hearing. Huh?
ಬಿಟ್ಟಾಗಿಲ್ಲ.
ಹೌದು,
dispose
ಅದೇ.
ಮಾಡ್ಬೋದು.
ಎಲ್ಲಿ ನೀವು ಇಲ್ಲೇ ತಂದು ಪೇಪರ್ ತೆಗೆದು ಓದ್ತಾ ಇದ್ದೀರಾ? How can I dispose? Nobody is ready. Yes.
Records may be called for witness.
Yes. Heard.
In this case, the commissioner has appointed and he's furnished a report also. Say this for a filing objection from my side. Drawing of final degree may kindly be stated. Otherwise, the appeal will
Yes,
be.
Heard. Admit. Drawing of final degree proceedings is stayed. Yes. 4 weeks time is granted to file a paper book.
Mobilize.
48 adjourned, serial number 48, Prakash Akane for a plate, here Rajshekhar
40? 40?
2 weeks and 47.
47. It will come after 2 weeks, Mr.
47.
Bharat, next week and next Thursday, Bharat. Yes. Next week it is already ordered, yes.
Serial number 49, Prakash Akane for appellant, Rajshekhar Pandya.
Who has filed an application?
J. Kumar.
What is this, Mr.? Who is? You will give the copy. Who is appearing for that appellant? Who is appearing for the appellant? What is the suit for? You are a plaintiff or a defendant? You plaintiff or defendant? What is your suit? Declaration and possession. You are claiming on what the basis of?
They are saying that the suit is declared, where the sale date stated 31/2016.
What is your interest, Mr.?
Leading applicant is a purchaser from the good sale deed. That one Ramakrishna has made as a defendant. That Ramakrishna has entered into agreement that he not executed the sale deed. We filed a suit for specific performance where Milord suit is decreed and court has executed in the through court medium. Milord sale deed was executed. In respect of that property, we have taken position. We are in possession of the property. Without making me as a party against Ramakrishna, they obtained a decree.
No, that,
now I am the
no, they have sought for an set-asiding that.
Judgment and decree by Ramakrishna is seeking for setting aside the said judgment.
No, that they are seeking for a sale deed.
Yes,
That is not related to you.
I am the purchaser from Ramakrishna. There is a decree against me and the court has executed sale
No, that is true, Mr.
Yes,
What are these sale deeds?
but these sale deeds, Milord, as between them, they are saying that it is not binding on the court is declared as null and void, not binding on the plaintiff. So my rights are accrued because I am in possession. If the decree they want to execute, I am a proper and necessary party. Therefore, my interest is to
No,
protect
Mr.
it.
Their case is to wait, Mr. Their case is to declare that sale deed executed by that Ramakrishna
Yes,
in favor of some other person.
yes,
That sale deed has been set aside.
aside and
Sale
also
deed-
court has directed deliver the possession of that property. In very same property, I am in possession by virtue of the similar another court decree. Therefore, we are now
You can be an objector in that execution because by set asiding the sale deed, it is clear your right. Therefore, other sale deed against you has been set aside now. Now that you are the only person has a right over the property.
Yes, I am in possession of property by virtue of the sale deed, court sale deed. That fact has to be decided here because Ramakrishna is challenging very same judgment.
Yes, will you give the copy, will hear.
Yes,
Yes. The impleading counsel for the impleading applicants is directed to serve impleading copy, a copy to the respondent. Yes.
Number 50, 51 adjourned, admission matter, number 52, TM Vishwanath, number appellant, connected matter,
Yes.
No. Connected matters, I want some time to file paper book.
No, that arising out of the same judgment.
Same judgment.
Then you need not file in a paper book. One paper book is enough.
Enough. But in the copy.
Copy ಕೊಡ್ತಾರೆ. Yes. That in your case, non-amendment of cost title.
ಅಲ್ಲ ಅದು I have to amend the cost title. ಎಲ್ಲಾರ್ಸು ತರಬೇಕಾಗಿತ್ತು ಅಂತ I will amend it.
Vacating the interim order filed by the whom you have filed this.
ಅವ್ರು ಹಾಕಿದ್ರು ಎಕ್ಸಿಕ್ಯೂಷನ್ ಹಾಕಿದ್ರು ಅದ್ರಲ್ಲಿ ಸ್ಟೇ ಆಗಿತ್ತು ಅದನ್ನ
Okay. Non-filing of acknowledgement having served the
ಸರ್ವ್
copy.
ಮಾಡಿದ್ದೀನಿ ಕಾಪಿ ಇದೆ ಕಾಪಿ ಕೊಟ್ಟಿದ್ದೀನಿ
ನಿಮ್ದು ಅಪೀಲ್ ಎರಡನೇ ಅಪೀಲ್ ಅಡ್ಮಿಟ್ ಆಗಿದ್ಯಾ?
ಆಗಿದೆ ಸ್ವಾಮಿ
ಆಗಿದಂಗಿಲ್ಲ ನೋಡಿ ಅಪೀಲ್ ಅಡ್ಮಿಟ್ ಆಗಿದೆ.
ಆಗಿಲ್ಲ ಅಡ್ಮಿಟ್ ಆಗಿದೆ
ನಿಮ್ ಮ್ಯಾಟರ್ ಅಡ್ಮಿಟ್ ಆಗಿದ್ಯಾ ವಿಶ್ವನಾಥ್? Formally, we will admit that. Yes. Both the appeals. Admitted, heard admit. The net counsel for the appellant has already filed in a paper book. Same is taken on record. Second matterly, filing of paper book is dispensed. Week time is granted to amend the cost title.
Yes, madam.
Yes.
Extended. for
Post this
execution.
matter for hearing. Interim order granted earlier is extended till next date of hearing. Yes. You amend it, Mr.
Yes, sir, I'll amend it.
Nagendra Shetty for appeal. Bill number 53, Nagendra Shetty.
Yes, madam, what is this?
Yes, my lord, it is for full of money, sir. And an amount of, on the basis of two checks, the admit has been passed 50,000 with an interest of 18% per annum, from the date of the filing of the suit. But, after filing of the complaint only, suit has been brought up. Suit has been instituted against this defendant, and in PCR, they have, she has paid 60,000 total. And also he has, the respondent initiated a proceedings against the bank with respect to misplacement of those two checks. And he has collected 30,000 rupees as compensation in the redressal form. That amount also coming from this check only. Hence, she's totally 60,000 plus 30. Only she has to pay 10,000 rupees, and also interest is exorbitant. For which
Now there is a direction to pay 50,000 with 18% interest. Yes, you take notice.
execution petition is also pending. While they have initiated a execution petition, and that may kindly be stayed.
You take hand summons or issue notice. In addition, appellant is permitted to take out hand summons to the respondent. Yes. You serve it and move that.
Same as
2021, madam. You serve the copy and move that matter. Yes.
Number 54, Subhash Chandra Bose for appellant. Nagaraja RJ.
Present.
Yes. What is this, Mr.?
Amount basing on the agreement of sale.
Hmm.
In fact, suit was not maintainable unless it was filed for the specific performance of the contract. By for recovery of the money. It is not the promissory note or agreement of money lending. However,
Oh, what is the transaction?
transaction. The owner of the property agreed to sell the property for the 45 lakhs, my lord.
Who?
The appellant hearing, my lord. Still, forever, we are ready and willing to perform my part of contract, my lord. Presently also.
No,
Appellant
no,
is present.
is there any settlement? Why that party says?
We are ready to take the 11
No,
lakhs.
is there any direction for parties to be present before the court?
Yes, my lord.
Direction ಏನಿರಲಿಲ್ಲ.
Yen settle, is there any possibilities of settlement?
But ನಂದು 11 ಲಕ್ಷ
ಎಷ್ಟು 11 lakhs,
45 lakhs. We have advanced
for
11 lakhs.
45 lakhs for that property.
Consideration was 45 lakhs.
45 lakhs.
ಅದರಲ್ಲಿ 11 ಲಕ್ಷ
ನೀವು ಕೊಟ್ಟಿದ್ದೀರಾ. Now the direction to pay that 11 lakhs.
ನನ್ನ ಸೂಟ್ ಇರೋದೇ ಅಷ್ಟೇ. My prayer is like.
You are giving up that interest.
ಬಿಟ್ಬಿಡ್ತೀನಿ.
Yes.
She and her brother entered into agreement of that. Our brother is no more. She is a father and brother. There is no father, there is no brother. She is alone.
Allah, now whether you want that property or a money.
We want to give money.
45 lakhs if they give, you will give back that money. Then you give that 45 lakhs and they will execute that.
First we have issued a notice. ಬನ್ನಿ ರಿಜಿಸ್ಟರ್ ಮಾಡ್ಕೊಡಿ. They have not come.
ಆಯ್ತು, now they are.
And meantime, we got a.
Already now they are ready to execute that agreement.
ಏನಾಯ್ತು?
Is that property is not valid 45 lakhs?
ಅದಲ್ಲ ಪ್ರಶ್ನೆ.
ಅದಲ್ದಿದ್ರೆ ಯಾಕೆ ಯಾರು ತಗೊಳ್ಳೋದಿಲ್ಲ? She don't want property, you don't want property. Why?
He has committed suicide.
Who?
His brother has committed suicide.
Hmm.
No.
No, they are selling the property. What is there in that? You are paying that money and purchasing, not that you are grabbing. If the part is remaining esto in 34 lakhs, they are ready to execute the sale deed. Then you take.
There's a due either bank and due either. They have taken.
ಅದನ್ನ adjust ಮಾಡ್ಕೋಬೇಕು. And you
Clear,
have
now they have to clear.
no, you have to pay that amount to that bank and get it clear.
ಎಷ್ಟಿದೆ
And
ಅಂತ?
there-
Suppose
ಅದಕ್ಕೊಂದು agreement
suppose it
ಮಾಡ್ಕೋಬೇಕು.
is more than 45 lakh.
ಎಷ್ಟಿದೆ ಬ್ಯಾಂಕ್ ಅಲ್ಲಿ?
Receive back the money whichever after deducting the bank loan.
ಆಯ್ತ್ರಿ, ಅದು ಅವ್ರಿಗೆ ಹೆಂಗ್ ಗೊತ್ತಾಗುತ್ತೆ ನಿಮ್ ಬ್ಯಾಂಕ್ ಲೋನ್?
After he will take the statement of.
ನೀವು ಬ್ಯಾಂಕ್ ಅಲ್ಲಿ ಎಷ್ಟಿದೆ ನೋಡಿ, ಅದು ಬ್ಯಾಂಕ್ ಅವ್ರನ್ನೂ ಒಂದ್ಸರಿ ಹೋಗಿ ವೆರಿಫೈ ಮಾಡಿ ವೆದರ್ ದಟ್ ಇಸ್ ಕರೆಕ್ಟ್ ಆರ್ ನಾಟ್, ಬಿಕಾಸ್ ಯು ಆರ್ ಪರ್ಚೇಸಿಂಗ್. ಆ ಬ್ಯಾಂಕ್ ಅಲ್ಲಿ ಎಷ್ಟು ಅಮೌಂಟ್ ಇದೆಯೋ ಅದು ಬ್ಯಾಂಕಿಗೆ ಕಟ್ಟಿ ರಿಮೈನಿಂಗ್ ಅವ್ರಿಗೆ ಕೊಟ್ಟು ಸೇಲ್ ಡೀಡ್ ಮಾಡ್ಕೊಳ್ಳೋದಕ್ಕೆ ಒಂದು ಅಗ್ರಿಮೆಂಟ್ ಮಾಡ್ಕೊಂಡು ದೆನ್ ವಿ ಕ್ಯಾನ್ ಪಾಸ್ ಎನ್ ಆರ್ಡರ್. ಯು ಸೆಟಲ್ ದಟ್ ಮ್ಯಾಟರ್ ಬಿಫೋರ್. Not directions, mister. That is, first we have to go and see that what is the due amount. Then you also verify whether that is correct or is there any other bank this thing.
Now, details ಕೊಡ್ಬೇಕು. They have to give it.
ಆದ್ರೆ ಅವ್ರು ಕೊಟ್ಟ ಮೇಲೆ ನೀವು ನೋಡ್ರಿ ಅಂತ ಹೇಳ್ತಾ ಇರೋದು. Then you verify, then you come to that conclusion that you pay that amount which is due in that bank. Remaining, you have pay that and get it sell it executed. Yes. When do you want? Yes, please this Mr. next week. In the meantime, we verify what is the bank due. Then we will see. Yes.
Much of it.
Yes.
Mahalaswamy.
Date will fix us with.
Partition ಬೇಡ, ನೀವೇ ಕುತ್ಕೊಂಡು ವೆರಿಫೈ ಮಾಡಿ. You and your colleague. When need not be come before the court. First you ask your client to that what is that due they have given.
Make it 17 or 18.
I leave this matter on 18. Yes.
Mahalaswamy.
Evidence number 192 of the Miller, 124 of the Miller. The respondents are the plaintiffs before the trial. For the relief of these being to be raised and injunction. Court Miller and it is by decree in the suit, court has recorded a finding that plaintiffs are the entitled for relief of declaration and possession. Not by page. Kindly look at prayer, not page issued order, page 42 may kindly look at that. The order Millard is suit of the plaintiff is decreed. Next page, Millard defendants are hereby directed to remove the obstructions caused to the scheduled property and restore the scheduled B property. Millard, the finding now, page 42, issue number 4, answer may kindly look at that account 18. Of my findings on the above issue number 1 to be the plaintiffs are entitled for the relief of declaration and possession.
Declaration anta andre now that you see that operative portions of the order. That operative portion says
And apart
that maybe
and apart from the merits of the case, Millard is concerned that the plaintiffs filing under 180 Millard, that is they have produced before the trial court the exhibit P1. 1991, where Millard, their contention Millard is that under the A scheduled property, they have purchased the A scheduled property, and B scheduled property they are seeking for relief for.
No,
That is a road. That road was obstructing by the defendants, therefore they want to inject it against the defendants.
that is that A and B scheduled properties belongs to you.
What happened, my lord? A scheduled property sold by them. That was a composite property, 1 acre 35 gunta iddu. 35 guntas was sold to us. Northern portion they have retained. In that northern portion, there is a road for me to access, my lord. That road leads to main road, my lord, Kundlalli to Odi main road, my lord. In the sale deed, my lord, northern boundary it has been clearly mentioned, the road and the one's remaining property, my lord. That is the only road, my lord, which is access for me, my lord. That has been proved And he accepts, my lord, there is one exhibit P90 cleared because I got the conversion of the land, my lord, the road has been seen. Witness admits, my lord, the defendant who has been examined, that there is a road as per the exhibit P19,
Yes,
my lord.
Mr. You have sold the portion of the property.
We are not disputing that we sold and
No,
there is
he-
a road.
he
We
has-
have that portion to the road. They can use the road, but they want to their, on the basis on the sale, they are not seeking. They want to leave what the property retained in the northern portion of the property, where they want to divert the road portion from lengthwise, midwise the road we have given, 25 feet mid road. Not we have submitted the records and there is an evidence and admission is clear that by selling the property, we retained property is clearly indicated. We shown that which property we shown. Not in between their property and my property, there is a road. Let them use that road, but they don't want that road. They want to lead main road. There is sub road with another 20 feet road is there. They don't want that road. Wherever we retained portion, in that portion they want. Boundaries may kindly look at exhibit P1 sale deed.
No, have you produced the sketch?
Kindly see, there's only 2 documents I will take your lordship, my lord. Kindly see exhibit P and trial court records have come, my lord. Because on that basis only, my lord, the matter was not admitted by earlier, my lord. Is now, what the sale deed and the, my lord, they are taking an entirely different stand, my lord. P19. Evidence. Deed of evidence. Kindly see exhibit P19, my lord. Now kindly see this portion, my lord. This is the portion, the bottom portion. This is purchased by me, my lord. Out of 1 acre 35 guntas, 35 guntas was purchased by me, my lord. At the time of selling, my lord, that upper portion, my lord, the top portion, which was retained by them, there is a road already in existence. That is a road which is marked, my lord. Without this road, my lord, the conversion order could not have been granted, my lord. Because he was entangled in the earlier litigation, my lord, with some other persons, my lord, I could not develop the property, my lord.
Which is the property you have purchased?
This is the bottom, that town portion, my lord.
In the middle.
Southern portion, this one, my lord.
Middle box.
This is the property retained by the vendor, my lord, the defendants, my lord.
This road.
There is a road in that property, my lord. This is the only road, kindly see, my lord.
No, is there any other road to access to that main?
That's why in the evidence it has come, my lord. There is no other road, kindly see, my lord. These are the 2 properties which bound on the northern side and the southern side. Southern side and the western side and the eastern side. I am bounded. On the southern side also I am bounded. Kindly see, my lord.
I pray.
I am not a party to the conversion order. The alleged conversion was made subsequent to the sale deed.
No, where is that access road for him?
For
go to the
access to the road, this plan may kindly look at the northern boundary may kindly look at 25 feet road is there. 25 feet road, they want to we have produced now we are producing the
No, Mr. Vijay Kumar, you have seen the sketch.
Yes, Millard.
Where is that road to reach that main road?
Not that is the road. They have a road to access. This is the road, Millard, what we given a road this portion. They want lengthwise to this main road. There is already a road leading to this road.
ಈ ರೋಡ್ ಎಲ್ಲಿಗೆ ಹೋಗಿ ರೀಚ್ ಆಗತ್ರಿ?
This road leading to Rasta main road of
main road, my lord. Kunzali Udi main road, my lord. This is
ನೀವ್ ಹೇಳ್ತಿರೋದು ಈ ಅಡ್ಡ ರೋಡ್ ಇದೆಯಲ್ಲ?
This plan may kindly look at. I have already furnished.
Boundaries mentioned in the sale deed and is evidence, my lord. There is no such road, my lord. The evidence clearly admits there is no such road.
This document, Millard, as last time, Millard, the court has directed me to produce a photograph and the plan entire with respect to that. That may kindly look at the plan I have produced. Where in this plan, Millard, this portion, Millard, admittedly we sold the property to them. This is the property has been sold to them. We retain this property. This in between the 25 feet road is there. This road they can use it. They want to say that they want straight road for this road. Main road. That is not the sale it contains.
They want from where?
This is the road is there.
Yes.
We have given 25 feet road in our land.
Now where they want to go? Which
They
is
want to go this road. This is only the road.
No, now which is the road they are claiming, mister?
But they are paying for this code.
Which one?
If they want to proceed with the area of 27 hectares, is there that demarcated time, you can that 27 hectares area owners remaining land survey number 13/5. That it is belongs to the Shamshad and his brothers.
ಆಯ್ತ್ರಿ ಅವ್ರದ್ದು ಮೇಲಿರೋ ಪೋರ್ಷನ್ಸ್
Not this is their property, this is our property, in between 25 feet road we have.
ಇದು ಎಲ್ಲಿಗೆ ಹೋಗುತ್ತೆ ರೋಡ್?
This existing public common road, one more road is there.
This will connect it to that.
Yes.
Then it
They
will come.
want main road, they want northern road, that is not our case, they will go to make any expert. Anyways, we will enter, that's the time is there.
No, mister. There is a road.
No, my lord, this is kindly similar. Now,
You want road in this middle of his property.
my lord, that was the road. There is no other road, my lord. If there is a road, he would have produced that. He would have produced.
We'll admit it.
Maybe taken up, my lord, kindly see, my lord. The only obstruction, my lord, I could not develop since 91.
Has to be heard.
Allah, one day our evidence ತೋರಿಸ್ತೀನಿ because whether is submission made before this court is correct. Kindly see, my lord. One statement. Let him not mislead the my lord. Kindly see, my lord. One paragraph I will read.
I pray it is for the court to decide whether it
That's
has to
why,
be
my
heard
lord.
finally or at that admission stage. Now he has made out in a case. I have to admit this is in a first appeal. It's in a right of appeal.
My lord, first appeal, my lord. Kindly see, my lord. The document which was not produced before the court. Now he comes up with some new case.
So that during the pendency of the suit, we have any injunction order.
My lord, now that's a mandatory injunction, my lord. I am not kindly see, my lord. There is a road access, my lord, which is
No,
blocked.
mister, you answer my question.
No,
During
there
the pendency of the suit, is there any temporary injunction order?
I can't seek, my lord. I only seek mandatory injunction to remove the obstruction, my lord.
Yes, then we will see that.
Already there is a
We'll
lot
admit.
of status granted with this code.
What is the use in status quo, mister?
Where status
Road
quo-
is already black. What is the use in status?
Allah, Swami, one paragraph I made permitted, kindly. One
Yes.
paragraph.
Heard. Admit.
And if we want to make any expense.
Yes, interim order granted earlier is extended till
Then
next
it may
date.
be
of
taken up,
hearing.
my lord, after 2 weeks, my lord. Kindly.
Yes. File a paper book. 2
Allah,
weeks.
without even it can be, my lord. There's only two, my lord, documents and the evidence, my lord.
How many evidence are there?
My lord, this because the main evidence, my lord, what they have given and my evidence, my lord. And the sketches, my
No,
lord.
how
One
many?
witness is there,
Huh?
two witnesses.
Two witnesses are there, my lord. With the documents, it can be heard, my lord. It can be taken up next week or day after.
Yes, mister, you file in a paper book within 1 week, mister.
Yes,
Yes.
2 weeks within 5 weeks.
Yeah. How to admit. Interim order granted earlier is extended till next date of hearing. The appellant is directed to file in a paper book on or before 23rd of January. Leave this matter 31st. Yes, for hearing. Yes, ಆಗಿದೆಯಾ? Interim order granted earlier, if any is extended till next date of hearing.
Appealing for the petitioner in the serial number 57, my lord.
Yes. One time. Yes, at the request of counsel for the appellant.
Opposite
Leave
counsel
this
has been.
matter after 2 weeks.
Additional appeal for appellant, Srinivasa PS.
You want passover? Yes, you want time? Yes. At the request of counsel for the appellant, leave this matter next week. This is the problem now, passover. If they want to extending that interim order, it will be passover. Tomorrow.
Execution.
Yes, leave this matter on 16th. Yes. Interim order granted earlier is extended till next date of hearing.
Serial number 59, thinking Bhavana for appellant, DL Lingaraju.
Yes.
This case is not yesterday also punished one more IA. Kindly press 2 week time may be granted. File objection to application.
Yes, madam.
For bare injunction.
Hmm.
For bare injunction, the defendant, for bare injunction decree. When the plaintiff claims that he is the authority of the site being formed by Bayankavat Society, House Building Cooperative Society in Nagavara village and filed the suit for injunction. When our issue of defense have filed in statement, where it was clearly stated that the entire land that was acquired by the media for the purpose of the house building societies, 7 house building societies, was by various by the land of by the dishonorable court in various petitions filed by various landowners, which
Yes.
went up to Supreme Court, and in one of the cases, the court has held that whether or not the landowners has questioned the acquisition, the possession of the property has to be returned to the landowners after collecting the compensation.
Yes.
Thereafter, my lords, the compensation has been returned and the possession has been handed over to the landowners by grant of Superdi Patra. And thereafter, my lords, for the change of RTC entries,
Yes.
when the landowners approached the Tahsildar refused it. They
No,
filed
this
a
is-
petition.
Suit for bare injunction.
Suit for bare injunction.
Only-
All these petitions for bare injunction has been placed for the trial court. And
No, only point is whether he is in the position as on the day of filing the suit.
no, my
It is
lords,
not
in
for
the
declaration.
in the cross examination, he has stated
No, the-
that the position was.
Wait. Now the trial court has decreed the suit, saying that he is in the possession.
The trial court has decreed the suit by holding that the acquisition was quashed only with respect to one survey number. This survey number acquisition was not quashed, and therefore I am granting injunction.
Yes.
So in suit for injunction, the declaration has been granted and it is a vacant site, and
Now
therefore.
that what has happened during the pendency of the suit, has he any injunction interim order?
Yes, my lord, there was an interim order in our favor.
What is that interim order?
And against that,
Hmm.
and in amendment it was clarified that status quo is to be maintained. Status quo has been ordered on the previous date of hearing.
Then
The
we'll,
application I have filed my lords, initially at the time of filing and not take advantage of the court because the order details there's also to the effect of declaration of title being given. I filed one application saying not to create third party rights, and another application typographical error was there IA number 2. I'm filing a memo on the counter saying that not press the IA number 2. In place of IA number 2, I have filed a fresh IA copy of which is being produced, seeking for not to interfere with the position.
no, that status quo has already been granted in this appeal.
This was on the previous date of
Then
hearing.
what else you want?
I want the extension of this order that is
We'll admit that appeal.
Yesterday, sir, the application,
I
to your
heard.
properly objection.
No, that heard admit. Parties are directed to maintain status quo. There is already an order.
MFNL.
ಅಲ್ಲ ಇಲ್ಲೂ ಆಗಿದೆಯಾ?
The last hearing order.
Yes, parties are interim order granted earlier is extended till next date of hearing. 4 weeks time is granted to file a paper. Yes.
Can be taken up for fine.
Yes, 6 weeks time is granted to file a paper book. Yes.
Serial number 1, Adinarayana for appellant, Guru Prasad VR.
Also,
Serial number 2, Udindra SD for appellant, Murli M.
also,
Serial number 4, Sampatanand Shetty for appellant, Dhanalakshmi Y.
so,
Serial number 10, KLSP SD.
also,
Number 35, Shravan S. Bokre.
yes. Memo for valuation guidelines flag. Where is that guidelines value you have produced? Yeah.
15 June 23. But there was no valuation mentioned in the trial form.
You can produce here. What is that valuation according to you?
In that it is the market value for the property. Relevant proof is verification as far as that is.
Totally the value is
1,800 per square feet.
Hmm.
For total measurement of 8,864.2 square feet. 5 lakhs and odd. Total value of scheduled property being 5 lakhs 9,000.
5 lakhs ಅಂತ ಅಂದ್ರೆ how can you approach High Court? It is Bangalore. Then it's before that single judge.
Yeah, there's some fear.
Yes.
Office,
What is that
clarification.
office objection?
That is, they want the court to accept this.
Well, it's along with that validated copy, yes.
They want the
Counsel
office
for
to accept it.
appellant has filed an elevation slip. Along with that application, other filed in a memo.
Details
Yes,
of,
as per the memo dated 14/6/2023, the properties is valid 5,09,261. Hence, appeal is maintainable before this court. As filed an evaluation, same is accepted. Office objection is overruled.
that
Yes, what is this matter, Mr.
suit is for partition, my lord.
Hmm.
There is no dispute regarding relationship of parties.
You are a plaintiff or a
I am
defendant?
the plaintiff, my lord.
Hmm.
My share is determined, but the learned judge gives the finding.
Hmm.
The property itself has been transferred to the first wife.
Hmm.
But the transfer is nullified, my lord. Actually, he could not have transferred. What was retained, there is already property which is retained. Evidence has come in, he has admitted, DW1 has admitted in the evidence that there is property available on the.
Now, who has transferred that property in favor of it?
The DW1 has 50% of the property. Father had two wives.
Hmm.
First wife's children, son, only son was available.
Hmm.
So he was the DW1.
Hmm.
The second wife's children, my lord, are these people,
Plaintiffs.
plaintiffs. There is no dispute about relationship. There is no admittedly, there is no partition in the family. Simply because some loan transaction was there years ago, and therefore there was a transfer made to the first wife, but it has again been given back to the husband. That document also was produced. The learned judge says that there is no, kindly see the last portion. Since there is no property available, I am holding that the suit is dismissed.
Yes.
It requires consideration.
Yes, admit. 4 week time is granted to file a paper book. Yes.
Serial number 43, Alesh Arvi, Ravi Shankar Ji, Praveen Kumar, LK for appellant, GS Patil.
Alesh Arji. Where is that? 230. Yes, none appear for the appellant. Leave this matter next week.
Serial number 44, M. Madhusudan Rao for appellant, M. Kumar Swamy.
So,
In a hearing matter, serial number 60, 61, 62 adjourned, serial number 63, LG Patil for appellant, Ajit KV.
yes, Mr. Clerk. Password. Yes, password. Password. Yes.
64 adjourned, serial number 65, HC Shivaramu, KV Venkatesh for appellant, J. Goyal.
Yes. Yes. Hmm. Is there a- Hmm. Yes. Yes. At the request of parties, leave this matter after 4 weeks.
Serial number 66 adjourned, serial number 67, Vinod Prasad for appellant, connected matter, Rahul Karyappa. Serial number 67,
Yes. Leave this matter 2 weeks.
serial number 68, S. Vishweshwaraya for appellant, Veeranaditi Gadi.
Why? What has it's a suit for partition? What has happened? Dismissed. Why? You are the plaintiff. Why it is dismissed?
That alienation has already taken place before the action came into force, but that is wrong. Because we have produced the sale deeds.
When has the sale has been taken place? You are the daughter.
Yes, my lord, yes, my lord.
When that properties has been sold. Sale was in 2023/11/2007. After the tax came into force, 2005.
No, my lord, not that.
Which is the date?
It's
Where is that issue framed by the trial court? Whether the plaintiff proves that suit scheduled properties are joint family properties. Affirmative, defendant proves that suit scheduled properties have been allotted to the shares of the husband of the oral partition. Prove the defendant a bona fide purchaser. Prove that suit scheduled properties are her self-assured properties as purchased same as the plaintiff. Affirmative. Additional issue.
The learned judge has held that the alienations are subsequent to 24/12/2004. But it is subsequent to 24/12/2004. But he has held that it is prior to 24/12/2004. That's why I want to convince your lordship. Lordship kindly have it next week.
Now, where is the sale deed? Have they produced?
No, we have they themselves have produced.
What is the date of the sale deed?
That's
Sale deed produced.
yes, I will get ready.
Registered sale deed on 2/4/2012.
Well, so that is after the act came into force.
Where is the finding?
Finding, my lords,
Additional
that
issue I have answered.
illy
Issue number 6, issue number 7 and 8. Where is that additional issue number 1?
additional issue, my lord.
Additional issue number 1.
Additional, that is regarding bona fide purchaser.
ಅದೇ ತಾನೆ ಇರೋದು ಮೇನ್.
ಅದು ಇದೆ.
Sitaram sale deed on 23/11/26 having
ಅಲ್ಲ ಇಲ್ಲಿ that's page 27. Page 27 and page conclusion is at page 28. ಅದರಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ last your lordship last para. Moreover, the first alienation is very much saved by section 6A of the Hindu Succession Act. Hence, according to me, the plaintiffs have failed to show that even now there exists a joint family and suit item number 1 and 2 are the joint family property. As such, suit item number 1 properties.
I have made it clear that both PW1 and DW5 rest to the court on the ground that exhibit 3 and 3. No doubt the suit item number 1 property earlier stood in the name of the Chikka Iranna. Further, this property was disposed of prior to 2004. Moreover, different alienation has been taken place starting from the hands of DW. It is only on the account of the fact that they have retained the joint family characters in this. No, first sale itself is 2004. It is out of your family.
There are 2 to 3 transactions that I will highlight. Lordship, kindly grant a week's time. Next Thursday. In fact, the other side also has that they are also not ready.
That is the only point. That is the only.
If the alienations are prior to Mallards, then it could be saved.
Yes.
Even otherwise, Mallards, under the notional partition, whatever the father has got, that must at least the father.
No, daughter has no right to file in a suit for partition. Before that amendment, if it is alienated.
Yes, sir, that is saved. That is saved. Suppose if I am able to demonstrate that is subsequent to.
Yes, that is the only point.
That's the only point, and then Mallards, the father in the father's share. Notional partition,
No, they have sold that property. Nothing has been left.
That
Yes.
Mallards.
Yes.
Next week.
Yes, leaves this matter on 17th. 17th. Yes.
Number 68, Chidambaram case to the client, directed matter, SP Prakash.
Yes. Yes, Mr. Chidambaram. What is this?
Still 9 for appellant.
What is this?
Petition suit, there are 2 appeals. Next week.
ಏನು ಯಾರು ರೆಡಿ ಇಲ್ಲಲ್ಲ ವಾಟ್ ಇಸ್ ದಿಸ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಷ್ಟೊತ್ತಿಗೆ ಇವೆಲ್ಲ ಹೋಗ್ಬಿಡ್ತವೆ ಡಿಸ್ಟಿಕ್ ಇಫ್ ದ ನೋಟಿಫಿಕೇಶನ್ ಇಸ್ ಇಶ್ಯೂಡ್ ದೆನ್ ಆಲ್ ದಿಸ್ ಮ್ಯಾಟರ್ ವಿಲ್ ಗೋ ಟು ದಟ್ district court. Yes. The request of counsel for the appellant, leave this matter next week.
Number 70, adjourn. 71, 72, and then serial number 73. A. Madhusudan Rao for appellant, connected matter, K. Siemens.
Yes. Case of, it would pertain to management. Two appeals, respect of the same properties.
Yes.
Arranged in different separate suits. One is by the son of the appellant in the first case. And that two times. That another, the one is the suit filed by the daughters. Seeking partition. Only contention in the appeal filed by me would be that because the daughters are all married prior to 1990. Because they are entitled to equal share also. That is one aspect. That there are two divergent issues taken by this. And all the legends in the single case of responsible won't have yet. Unless and until. Because they were married.
No, marriage is not in a criteria.
Like into 1990 Amendment Act. As per that, daughter is married earlier to 1990. Five new amendment came. If you get rid of this. And he has held that the daughters have already they have lost their right under the old act. They cannot claim their right, equal rights under the new act. Whereas a different view is taken by his lordship is the one ultimately will not what will be the law in respect of that will have to be decided in the first appeal. The second appeal, what is happening is an appeal filed by the legatee who claims to be that there is a bill executed by the client. He is the son of my client in the first appeal.
Yes.
There is a bill. So trial court had agreed this to first appeal. So that is on the basis whether the bill is proved or not. He is claiming.
No, one is RSA.
Both of them are RSA.
Then why it is before this court?
Because what has happened is it is a special order passed by the Honorable Court. The Chief Justice. That's all. The judgment is rendered by his lordship Justice.
No, now RSA is before whom?
RSA is before the judgment, correct, provided amendment. RSA is going to RSA.
Now that it has to go before the roster bench only. No, as long as when it is before the judge who said it is not before them, then after the roster is changed. As per that circular, it has to go before that regular bench.
The one is 2011 matter. Another one is 2018.
2024 post RSA. Matters before HD and teacher. ಯಾರ ಮುಂದೆ posted matter was on 2-1?
7 matter.
ಯಾಕೆ ಬಂತು ಹಿಂದೆ ಯಾರ ಮುಂದೆ ಆಯ್ತು? ಯಾರು ಸಂದೇಶ. Now that see ಅದಾದ್ಮೇಲೆ ಈಗ ನಾವು it has to go before that I think regular bench. RSA regular bench not before that ಅದನ್ನು ಕ್ಲಾರಿಫೈ ಮಾಡ್ತೀನಿ. ಅದು ಮೋಸ್ಟ್ಲಿ ಅವ್ರಿಗೆ ಗೊತ್ತಾಗಿಲ್ಲ. ಸರ್ಕ್ಯುಲರ್ ಪ್ರಕಾರ if I say as long as that bench which has not before me, the moment roster has been changed, it has to go before the roster bench because that roster bench is not disabled. That is what the circular.
That's right.
By here in this special order has been passed to verify. Next week. Yes. This matter. Even if that notification is issued, then it has to go before the division bench. You have more privilege. You have more privilege to argue before the division bench instead of single judge. Yes. Now that it is good that there is a two conflicting view, then division bench can consider. Yes. 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 Password. Hearing, which is your matter, Mr.
72, I think it's adjourned at the expense of the other side. 72.
Oh, yes. Chandan has taken time. Yes.
Any date fixed?
2 weeks, he wants 2 weeks. Yes. Anybody is there? Oh, you are ready?
I am ready. Pass over.
2:30.
After 2:30 ಅಂತಾರೆ. It will post it next week.
2:30, come, no matter is there, I will hear. Let us see. What is your matter? You just to give that brief.
That the appellant is the dependent in the trial court. It is the
The injunction suit.
Yes, my lord.
No, you are the plaintiff or a dependent?
Dependent.
Yes.
There, the respondent was the plaintiff. He has filed a fair suit for permanent injunction, including the site sold to me. Finding is in my favor.
Where is
Except but in the operative portion, that is not reflected.
No, your case is that this portion has been sold by the plaintiff to you.
Plaintiff's husband,
Plaintiff
that has
husband.
been admitted.
Where is that? Whether the possession is admitted, possession has been handed over.
Possession is handed over, even a sale is also executed by the GP holder of the plaintiff's husband in favor of dependent number 2.
What is the issue framed by the trial court?
Three issues, my lord.
Yellow page number.
Page number 7. Whether the plaintiff proves the law, possession and enjoyment of the fruit scheduled property as on the date of the suit. Whether the plaintiff proves the alleged obstruction from the dependent.
Now that whether possession has been proved.
Yes, my lord. Yes, they have admitted.
Yellow findings of course. You read that which is the
Page
paragraph?
number, page number 17.
You read para 12. From para 12.
Paragraph. Paragraph, my lord. On the other hand, it is the specific case of the dependent, the husband of the plaintiff by name late Nagappa had entered into an agreement of sale dated 6/1/1999 with the dependent number 1 to the extent of 1,200 square feet, and he had also executed a GP dated 5/4/1999 in favor of dependent number 1 and handed over the possession of 1,200 square feet in survey number 67/2 to dependent number 1. Thereafter, at 28/7/2004, dependent number 1 he executed a registered sale deed in favor of the dependent number 2 in respect of 1,200 square feet. Therefore, dependent number 2 became the owner of the area measuring 1,200 square feet in survey number 67/2, and she is in possession and enjoyment of the said area, and it is the further case of the dependent as they have not interfered with the plaintiff possession over the food scheduled property. Yes, dependent place to dismiss suit. Larger area I am not concerned, Your Honor. Only the property sold to me I am concerned.
No, is it that property sold to you is also part of the suit schedule?
Yes, my lord.
You read further why the trial court has given finding. Next,
Lord, kindly.
PW1 in cross examination. Allah, adrle next para odi. Yes.
PWC holder of plaintiff in his affidavit has reacted and affirmed the contents of the plaintiff government and got marked with the document now 3-16. The description of the document.
Next page, Ibani. Next page.
Next page, 100.
PW1 in his cross.
PW in the cross section led by the dependent counsel has stated he is the grandson in transport business. The property comes to the husband of the plaintiff from his grandfather. State Nagappa was given share in survey number 67/2, and during like Nagappa sold some portion to different person and executed agreement of sale in favor of dependent number 1 on 6/1/1999 by receiving 1,60,000. He denied the sales that possession was given to the dependent number 1 on the basis of sale agreement. He further denied the sales that the said Nagappa had executed GP in favor of dependent number 1 on 5/4/1999, and he further denied the sales that the dependent number 1 had sold an extent of 1,200 square feet in favor of dependent number 2 in the month of July 2004, and he further denied sales that the dependent number 2 has continued in possession of the said portion after purchase of the same from the dependent number 1, and he has stated that in the month of August 2004, defendant tried to put up compound wall and he denied, says that plaintiff is not in possession of social property. Further matter. DW1, in his affidavit, has reiterated and reaffirmed the contents of the written statement and not marked the documents at exhibit D1 to D16.
Yes.
Description of D1 is the document submitted by a minor, by the defendant. D1 is xerox copy of the agreement itself.
ಅಲ್ಲ ಅದ್ ಬೇಡ next ಬನ್ನಿ DW1 in his class examination.
DW1 is class agreement led by the plaintiff counsel has stated that he has stated up to 9th standard. He has stated that in respect of the deliberate position, there is a recital in exhibit D2. He has admitted the session that for want of money, date of marriage of the plaintiff's husband, he has executed agreement of sale exhibit D2 in his favor. He denied a session that Nagappa had not received consideration amount and not executed any share on exhibit D2. He further denied the session that he had not taken possession of the social property and he further denied the session that he has created exhibit D3 and D4 and he further denied the session that he was not in possession of any portion of the survey number 67 part 2 and he further denied the session that plaintiff was in possession of social property. The plaintiff has relied upon the document P to mutation extract clearly goes to show that as per the order passed in OS number, that is a part of filed by the husband of the plaintiff.
Yes.
OS number 14, 13, 19, an extent of land measuring 84 plus 80 or 2 feet into 330 feet was allowed to the share of the husband of the plaintiff by name Nagappa. According to the case of the plaintiff, her husband Nagappa had sold an extent of 1,000 square feet in favor of defendant number 1 and executed agreement in favor of defendant number 1 on 6/1/1999. As per the contention of defendant number 1, said Nagappa had also executed a GPA in favor of him dated 5/4/1999. Therefore, remaining extent of 67 that is suit and property was with the possession of the late Nagappa. The plaintiff has contended that defendant number 1 neither paid the sale consideration amount nor completed the sale transaction as per the agreement of sale dated 6/1/1991. Therefore, the sale agreement is time barred. But as per the contention of defendant number 1, the husband of the plaintiff late Nagappa not only executed agreement of sale dated 6/1/99 to an extent of 1,200 square feet in survey number 67 part 2, but he has also executed GPA in his favor, defendant number 1, in favor on 5/4/1999. Therefore, defendant number 1 had executed sale deed with respect to 1,200 square feet in survey number 67 part 2 in favor of defendant number 2 on the document relied by the defendant number at exhibit D2 agreement of sale, which clearly goes to show that the husband of the plaintiff by name Nagappa had executed agreement of sale dated exhibit D2 in favor of defendant number 1 on 6/1/1999 to an extent of 1,200 square feet in survey number 67 part 2. And exhibit D3 declaration is important. The declaration executed by the Nagappa in favor of defendant number 1 goes to show that said Nagappa has declared that he has received a sum of ₹1,60,000 from the defendant number 1 as a full sale consideration in respect of the extent of 1,200 square feet and sold the same in favor of defendant number 1 and exhibit D4 GPA dated 5/4/1999 executed by the said Nagappa clearly goes to show that the said Nagappa had executed exhibit D4 GPA in favor of defendant number 1 with respect to extent of 1,200 square feet in survey number 67 part 2 and defendant also relied upon the exhibit D5 sale deed deed of absolute sale, which clearly goes to show that defendant number 1 has executed exhibit D5 in favor of defendant number 1 with respect to the extent of 1,200 square feet in the survey number 67 part 2. Exhibit D6 to D8 as per visit clearly goes to show that the defendant number 1 had paid tax with respect to an extent of 1,000 square feet of land in survey number 67 part 2. Exhibit P9 property tax rate goes to show that he has an extent of 30 into 40 feet in survey number 67 part 2. 1,200 square feet is standing in the name of defendant number 2. SB D10 to D15 tax basis goes to show that dependent number 2 had paid tax in respect of 1,200 square feet land in survey number 67 part 2. SB D16 encumbrance certificate goes to show that the dependent number 1 has executed sale deed in favor of dependent number 1 with respect to 1,200 square feet of land in survey number 67 part 2. So the document relied by the dependent are pertaining to Nasrud property. After exclusion, my lord, after exclusion of 1,000 square feet of land, 67 part 2, standing in the name of dependent number 2, the suit settled property remains with the possession of the plaintiff, and the plaintiff continued to be in possession of the suit settled property after death of her husband Nagappa. The document relied by the plaintiff at exhibit P2, mutation register, extract and exhibit P3, RTC, extract goes to show that the extent of 84 plus 80 per 2 feet into 330 feet in survey number 67 part 2 was standing in the name of husband of the plaintiff by name Nagappa. And as I have already stated, the husband of the plaintiff had sold an extent of 1,200 square feet in survey number 67 part 2 in favor of dependent number 1. Under the agreement of sale and executed GPA in favor of dependent number 1, and as such, dependent number 1 has sold the 1,200 square feet in survey number 67 part 2 in favor of dependent number 2. Hence, the suit settled was remained in possession of the plaintiff's husband by name Nagappa. Here, B6 death certificate goes to show that Nagappa had died on 17/9/2003. After death of, I have disputed that. After the death of Nagappa, the plaintiff or children continue to be in possession of the enjoyment of suit settled property. Dependent are claiming the extent of 2,000 square feet of land in survey number 62, but as per exhibit P5 has the same standing in the name of dependent number, which is non-suit property. Spider. In spite of it, as per the condition, plaintiff dependent number 1 tried to interfere with the possession of plaintiff or suit settled property on 31/8/2004, and PW1 has also stated in his affidavit that dependent obstructed the possession of plaintiff or suit settled property on 31/8/2004. So it is crystal clear that the dependent have obstructed the possession of plaintiff over the suit settled property.
Now, what is that extent of land in that survey number 67 part 2?
That is 218 into 84 feet. That is 2,000. When I sent for the exhibit P4, they have produced the sketch.
43,
Number 49. For A, that is marked in the class examination.
Exhibit
Exhibit P4, and this portion is exhibit P4A. That has been admitted by the PW1 in the class.
There is no dispute that you have purchased that land. They are saying that that is not suit settled property. Adan bittu berediದೆ ಅಂತ.
ಅಲ್ಲ ಬೇರೆದು ಅವ್ರದ್ದು ಇದೆ. I admit my lord.
No.
But
suit settled property ನಿಮಗೆ ಮಾರಿರ್ತಕ್ಕಂಥ land is not included. That is what the finding of the trial court.
it is survey number is same.
Survey number same.
Same. The portion is the same.
See, now according to that suit settled property, they are seeking 218 feet from north to south, 84 feet from west, east to west. Andre S square feet ಆಯ್ತಲ್ಲಿ. S square feet ಆಯ್ತು. Total ಇರೋದು S square feet ಹೇಳಿ 67/2 ಅಲ್ಲಿ.
Measuring 218 feet into 84 feet.
ಅಲ್ಲ, ಟೋಟಲ್ ಮೆಜರ್ಮೆಂಟ್ ಎಷ್ಟು 67/2 ಅಲ್ಲಿ. ನಿಮ್ದು ಅವ್ರದ್ದು ಎಲ್ಲ ಸೇರಿ ಒಟ್ಟಿಷ್ಟು ಎಷ್ಟಿತ್ತು ಮೊದಲು ನೀವು ಪರ್ಚೇಸ್ ಮಾಡಕ್ಕಿಂತ ಮುಂಚೆ?
ನಾವು ಪರ್ಚೇಸ್ ಮಾಡಕ್ಕೆ ಮುಂಚೆ 330 feet and east to west, north side 84 into 80 feet. ಅನ್ನಿಸೋದು
ಎಷ್ಟಾಯ್ತು ಅಲ್ಲಿ?
suit settled property ಇದೆ ಅಂತ they say. They admit.
No, they are saying that ನನಗೆ ಸರ್ವೆ ನಂಬರ್ 67/2 ಅಲ್ಲೇ ನೀವು ಪರ್ಚೇಸ್ ಮಾಡಿದ್ದಾನೆ. ಅದರಲ್ಲಿ ಟೋಟಲ್ ಎಷ್ಟು ಎಕ್ಸ್ಟೆಂಟ್ ಇತ್ತು ಮೊದಲು? ಟೋಟಲ್ ಎಷ್ಟಿತ್ತು ಮೆಜರ್ಮೆಂಟ್? ನಿಮ್ ಸೇಲ್ ಡೀಡ್ ಅಲ್ಲಿ ಇರ್ಬೇಕು. ನಿಮ್ ಸೇಲ್ ಡೀಡ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದೀರಾ? ನಿಮ್ಗೆ ಎಕ್ಸಿಬಿಟ್ ಟ್ರಯಲ್ ಕೋರ್ಟು ನಿಮಗ್ ಮಾರಿರ್ತಕ್ಕಂಥ ಲ್ಯಾಂಡ್ ಸೂಟ್ ಶೆಡ್ಯೂಲ್ಡ್ ಅಲ್ಲಿ ಇಲ್ಲ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಇಫ್ ಯು ಶೋ ಮಿ ದಟ್ ಇಟ್ ಈಸ್ ಆಲ್ಸೋ ಪಾರ್ಟ್ ಆಫ್ ದ ಸೂಟ್ ಶೆಡ್ಯೂಲ್, ದೆನ್ appeal has to be allowed. Otherwise, it is an out of the suit schedule property.
No, it is within the suit schedule, plain schedule property.
ತೋರಿಸಿ. ಕ್ಲೈಂಟ್ ಅಲ್ಲಿ ಅವ್ರು ಹೇಳೋದು 280 feet into 84 feet. ಟೋಟಲ್ ಮೆಜರ್ಮೆಂಟ್ ಎಷ್ಟಿದೆ?
Finding of the trial judge after excluding ಉಳಿದದ್ದು ಅವ್ರದ್ದು ಅಂತ ಹೇಳಿ.
ಅಲ್ಲ, ಅವರು 67/2 ನಿಮಗ್ ಮಾರಿರೋದು ಬಿಟ್ಟು ಬಾಕಿದ್ ಮಾತ್ರ ಸೂಟ್ ಶೆಡ್ಯೂಲ್ಡ್ ಅಂತ ಅವ್ರು ಹೇಳ್ತಾ ಇರೋದು. ನಿಮ್ದು ಸೂಟ್ ಶೆಡ್ಯೂಲ್ ಅಲ್ಲಿ ಇಲ್ಲ.
But in the operative portion, my lord, they have not reflected in the operative portion.
No.
They have included
ಆಪರೇಟಿವ್ ಪೋರ್ಷನ್ಸ್ ಎಲ್ಲಾ ಕಡೆನೂ ಏನ್ ಹೇಳ್ತಾ ಇದಾರೆ ಅಂದ್ರೆ, ನಿಮಗ್ ಮಾರಿರೋದು ಹೌದು, ನೀವು ಪರ್ಚೇಸ್ ಮಾಡಿರೋದು ಹೌದು, ಆದ್ರೆ ಅದನ್ನ ಬಿಟ್ಟು ಬಾಕಿದಕ್ ಮಾತ್ರ ಪ್ಲೈನ್ ಶೆಡ್ಯೂಲ್ಡ್ ಇರೋದು ಅಂತ ಅವ್ರು ಹೇಳ್ತಾ ಇದ್ದಾರೆ.
ಹಾಗೆ ಹೇಳಿಲ್ಲ.
That is what that court said.
Bare suit for permanent injunction.
See, stand in the name of a defendant which is non-suit property. This is the finding. Which is non-suit property. Property which is standing in the name of defendant number 2 is non-suit property. Andre it is not a plain property anta finding. That is the finding which is given.
But it is the same property.
ನೀವು ನನಗೆ you have to convince me that no, this is wrong. ನೀವು ಪರ್ಚೇಸ್ ಮಾಡಿರೋ ಪ್ರಾಪರ್ಟಿ ಆಲ್ಸೋ ಇನ್ಕ್ಲೂಡೆಡ್ ಇನ್ ಪ್ಲೈಂಟ್ ಅಂತ ತೋರಿಸಿದ್ರೆ then you have a case. If it is outside that, show me that in that sale deed. In sale deed ಎಲ್ಲಿದೆ? ಅದಕ್ಕೋಸ್ಕರ I am asking, what is the total extent? Which is the sale deed? Agreement of sale ತೆಗಿರಿ, D2 ಅಥವಾ D5 ತೆಗಿರಿ. D5.
Whereas it is stated manner. Bill number 79, SB5. Whereas vendor is absolute for residential vacant site property, where in Khata number 278 property number 67, site number 67, situated Mahadevpura, KR from that is Suchadu, Bangalore South Taluk, Bangalore South now is presently comes under the jurisdiction of Mahadevpura CFD, Bangalore more fully described in the scheduled property here and here in the approved scheduled property. Khata and all of the concerned documents of the scheduled property stands in the name of vendor. The vendor is lawful and entitled to edit the same in any manner as the vendor likes. Whereas vendor has appointed MP Varghese, son of Kurian, as his attorney holder to do the lawful acts and things in respect to scheduled property by virtue of general power of attorney dated 5/4/1999. Accordingly, said power of attorney holder, he is executing the civil deed under this present. Exhibit D5 scheduled manner. On the piece and parcel of the residential removed vacant site bearing property bearing Khata number 278, block 3, property number 67, site number 67, situated Mahadevapura, Lingarajpuram, Bangalore South Taluk.
ಅಲ್ಲ ನಿಮ್ದು ಎಷ್ಟು ಗುಂಟೆ ಬರುತ್ತೆ?
1,200 square feet.
ಸ್ಕ್ವೇರ್ ಫೀಟ್ ಅಂದ್ರೆ ಎಷ್ಟು ಗುಂಟೆ ಬರುತ್ತೆ? Put off, sir. 1,200 square feet. ಎಷ್ಟು ಗುಂಟೆ ಆಗುತ್ತೆ ನಿಮ್ಗೆ? 1 ಗುಂಟೆ ಆಗುತ್ತೆ ಅಷ್ಟೇನಾ? ನಿಮ್ದು 1 ಗುಂಟೆ, ಅವ್ರದ್ದು ಎಷ್ಟು ಹೇಳಿದಾರೆ ಎಕ್ಸ್ಟೆಂಟ್?
218 into 84 feet.
ಎಷ್ಟಾಯ್ತು ಅದು? ಅದೆಷ್ಟು ಗುಂಟೆ ಆಯ್ತು? ಲೈನ್ ಶೆಡ್ಯೂಲ್ಡ್ ಪ್ರಾಪರ್ಟಿ ಇಲ್ಲಿ ಇದೆ. ಶೆಡ್ಯೂಲ್ ಅಲ್ಲಿ ಇದೆ. ಲಾಸ್ಟ್ ಇದೆ. ಸ್ಕ್ವೇರ್ ಫೀಟ್ ನೋಡಿ ನಾಲ್ಕಿದೆ ಬರ್ತದೆ. ಅದೆಷ್ಟು ಬರುತ್ತೆ? 218 into 84. ಎಷ್ಟು ಗುಂಟೆ ಸರ್? ಅಲ್ರಿ, ಇದು ಫಸ್ಟ್ ಸರ್ವೆ ನಂಬರ್ 67/2 ಅಲ್ಲಿ ನಿಮಗೆ ಮಾರಿರೋದು ನಾಗಪ್ಪನ ಹೆಸರಲ್ಲಿ 3 ಎಕರೆ ಇದೆ.
ಅಲ್ಲ, ಅದು ಬೇರೆ ಪ್ಲೇನ್ ಶೆಡ್ಯೂಲ್ ಲಿಸ್ಟ್ ಮಾತ್ರ ಹಾಕಿ ನಂದು ಇನ್ಕ್ಲೂಡ್ ಮಾಡಿದ್ದಾರೆ.
ಅಲ್ಲ, 3 ಎಕರೆ
ಶೆಡ್ಯೂಲ್ ದೇ ಹ್ಯಾವ್ ಶೋನ್.
Now that you show me your schedule and the plain schedule boundaries are tallying. Show me that what is the boundaries in your sale deed. Very plain. Into sale deed ಅಲ್ಲಿ boundary
entire
east to west private property, east private property. West by road,
total properties ತೋರಿಸಿದ್ದಾರೆ.
west road, north by private property.
ಅಕ್ಕಪಕ್ಕದೆಲ್ಲ ಬೇರೆ ಬೇರೆ ಮಾರಾಟ ಮಾಡಿದ್ದಾರೆ. They have admitted they have sold to different persons.
No, there is no dispute that they have sold to you also, but their case is that property which is sold is not in a suit schedule property, it is in a different. That is also finding of the
But the plaintiff's case is not that. They say that it is in the, it comes under the suit schedule property.
ಎಲ್ಲಿದೆ ತೋರಿಸಿ.
Their case is.
Where is that? Show me that.
Para 5 by that.
Yes.
It is submitted that this land having developed into a residential area and plaintiff deceased husband constructed residential premises for his own use as well as for the purpose of letting out. Thus constructed two tenements in his property during his lifetime to meet his family expenses and other exigencies. He sold constructed premises in the southern side, another portion in the northeast corner, as well as an area measuring 2,000 square feet along the western boundary. This is western boundary.
Sold to you?
Yes, my lord.
They are saying that property which is sold remaining, they are seeking for an injunction. You are, see.
They are not seeking for remaining, including my side.
No, they see the premises in the northern side, another portions in the corner, as well as the area measuring has been sold. Remaining ಮಾತ್ರ ನಾನು ಇಂಜೆಕ್ಷನ್ ಕೇಳ್ತಾ ಇದೀವಿ ಅಂತ their case.
No, my lord.
They have also not disputed that land sold to you. Only thing is land sold to you and the plaintiff suit property is overlapping or not. If it is not overlapping, then you have no case. The finding of the trial court is that there is no overlapping.
My submission, ma'am, the suit itself, where suit purpose itself is not met.
Why?
Because they have not saw any declaration of poison.
No. They are claiming that
Instead of specific purpose.
no, you have purchased 1,200 square feet. There are remaining extent also in that survey number. This is belongs to the plaintiff. You try to interfere to his property. Therefore, he has filed an injunction.
I am not interfering in the remaining portion.
No, you are
I am
not.
not concerned.
No, you yourself has not identified which is your 1,200 square feet.
But PW himself admitted the property sold to me.
No,
Exhibit P4 sketch, my lord, that
No.
is marked in P4A.
No, there is
That
no.
portion is marked in P4A, my lord. Please kindly refer the exhibit P4.
No, that is not the suit schedule property. What is sold is different. That is what their case. They are not saying that it is not sold to you. It is sold to you.
They are admitted in cross-examination, my lord. Not in their case. They are admitting that in cross-examination.
Portion of the northeastern corner as well as the area of measuring 1,200 square feet ಅಂದ್ರೆ ನಿಮಗೆ ಕೊಟ್ಟಿರೋದು ಅದು.
ನಮಗೆ ದುಡ್ಡುನು ಕೊಡ್ಲಿಲ್ಲ ಇದಂತ ಎವಿಡೆನ್ಸ್.
He sold that construction premises in the other side, portion in the northern side concern as well as the area measuring. ಎಲ್ಲಿ ಹೇಳಿದಾರೆ ಅದು ದುಡ್ಡು ಕೊಟ್ಟಿಲ್ಲ ನೀವು ಅಂತ? Show me is evidence saying that.
Exam chief of PW1. ಅದು ಮಾಡಿದಂತ ಅವ್ರು ಹೇಳ್ತಾ ಇದ್ದಾರೆ. ಪೇಜ್ ನಂಬರ್ ಪ್ಯಾರಾ 2 ಮೇಲೆ ಪೇಜ್ ನಂಬರ್ 27.
PW1
PW.
examination chief BW1. Yes. Cross examination.
Chief of permit to read para number 4.
Yes, read.
I submit as flat and developed into residential area, where the places was constructed the residential premises for its own use as well as for the purpose of livelihood. Thus, the plaintiff deceased husband has constructed about 12 tenements in this property during his lifetime to meet his family expenses and other expenses. Sold constructed premises in the central side and other portion in the northern side, as well as an area 1,000 square feet along the western boundary. Substance showing the details of the property, including the extent sold property totally measuring 27,700.
ಎಲ್ಲಿದೆ sketch?
Exhibit in page number.
ಕೊಡಿ. The exhibits ಅಂತ ಹಾಕಿದಾರಲ್ಲ, what is that?
Party name. They themselves produce the sketch.
Exhibit P4.
Exhibit P4.
ಇದ್ರಲ್ಲಿ ನಿಮಗೆ ಮಾರಿರೋದು ಎಲ್ಲಿದೆ?
That is marked exhibit P4A, my lord.
P4A.
Yeah.
Bearing 67 Madhapura, care from measuring. ನಿಮ್ ಪ್ರಾಪರ್ಟಿ ಎಲ್ಲಿ ಬರುತ್ತೆ ಇದ್ರಲ್ಲಿ? ಬ್ಲೂ ಕಲರ್. P4A ಅಂತ ಮಾಡಿದ್ದಾರೆ. ಇದ್ರಲ್ಲಿ ಕಾಣಿಸ್ತಿಲ್ಲ. ಅದೇ ಬ್ಲೂ. ಬ್ಲೂ ಕಲರ್ ಅದೇ P4. ಇದು ಎಕ್ಸಿಬಿಟ್ 4A. ಕರೆಕ್ಟ್. 4A is what? ಎಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ 4A ಅಂತ? ವೈ ಇಟ್ ಈಸ್ ಮಾರ್ಕ್ 4A?
Cross examination, PW admitted.
ಎಲ್ಲಿದೆ 4A ಅಂತ ಯಾಕೆ ಮಾರ್ಕ್ ಮಾಡಿದ್ರು ಅಂತ?
ಅಲ್ಲ, particular this property sold to me.
ಎಲ್ಲಿದೆ ಅದು?
Number 35.
Exhibit P4.
The
area sold to the first defendant is marked by blue marking. Now it is separately marked as exhibit B. It is not true to suggest
Page number 34.
that the property is given to the first defendant on the date of sale agreement. True to suggest that I have no personal knowledge of the sale agreement. I can identify the signature of Nagappa. Please shown to me.
Page number 34, last paragraph.
Iga,
Last paragraph.
as I read.
34, last paragraph, he admits.
Yes.
Now I see the document exhibit P4.
Yes.
The area sold to first defendant is marked by blue in ink. Now it is separately marked by P4.
ಈ ಸ್ಕೆಚ್ ಇದೆಯಲ್ಲ, ಇದು ಎಂಟೈರ್ ಸ್ಕೆಚ್ ಇಸ್ ದ ಸೂಟ್ ಶೆಡ್ಯೂಲ್ಡ್ ಅಂತ ಹೇಳಿದಾರ?
ಹೌದು.
ಎಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ? ಎಲ್ಲ ತೋರಿಸೋದು. Then finding of the trial court is wrong. This is excluding the suit schedule because it is within the suit schedule. You are admitted exhibit P4. Your case is that position is not handed over, but the finding of the trial court is position is handed over. Then there is a counter. 230. Yes, we'll see what he will say that. Next week, again ಬರ್ಬಿಟ್ಟಿದ್ದೀರಾ? It is already written on order sheet. No, 2 weeks ಅಂತ ಅಂದ್ರೆ it will come 23rd. 23rd. ಅಲ್ಲ, ಆರ್ಡರ್ ಶೀಟ್ ನೀವು ಯಾರು ಇರ್ಲಿಲ್ಲ, nobody was there. This matter next week ಅಂತ ಮಾಡಿ. Yes.
ನೋಡಿ ಯಾವಾಗ ಅಂದ್ರು
ಅದೇ ಇವ್ರು ಕೊಟ್ರು, ಜಮೀನ್ದಾರ್ ಕೊಟ್ರು, ಕೋರ್ಟ್ ಆಫೀಸರ್ ಕೊಡು ಅಂತ ಹೇಳ್ತೀನಿ. ಅರ್ಜೆಂಟ್ ಅಲ್ಲಿ ಇದ್ರೆ ಏನೇ ಹೇಳಲಿಲ್ಲ.
ರೆಕಾರ್ಡ್ ಇಟ್ಟಿದೆಯಲ್ಲಪ್ಪ ಅಲ್ಲಿ
ಇಷ್ಟ ಏನೋ ಗೊತ್ತಿಲ್ಲ, ನಮ್ಗೆ ಯಾವ್ದು ಸಿಕ್ಕಿಲ್ಲ ಅಂದ್ರೆ ಕೆಳಗಡೆ ಇತ್ತು. ಆಯ್ತಾ? ಇವೆಲ್ಲ ಹಿಂಗೇನೆ ಇರಲ್ಲ ಸರ್.
I don't Yeah.
Morning, I had mentioned one matter for interim order extension, serial number 14.
Now orders it has been signed.
I had informed on the side in the morning, won't take any time, it mentioned.
Orders it is signed, you have to file an application for extension.
Matter, serial number 1, Adi Narayana for appellant, Guru Prasad R.
ನಾರಾಯಣ. ಅಲ್ಲ ಇದಾಗಿತ್ತು ನಾವು ಕರೆಕ್ಟ್ ಪಾಸ್ವರ್ಡ್.
Serial number 2, Sudhindra SA for appellant, Murli M. Number 4, Sampathana Chetty for appellant, Dhanalakshmi Y.
Yes.
Seek for 1 week of.
Not counsel for the appellant press. Finally, weeks time to comply the top subjection. Yes.
Number 10, Vijayalakshmi SD. Number 44, M. Madhusudan Rao for appellant, M. Kumar Swamy.
Yes.
The amendment petition, appeal madam has been filed, madam.
Right. Yes. Learned counsel for the appellant. Appealing of the amended appeal memo. Aಷ್ಟೇ ಅಲ್ಲ?
ಅಷ್ಟೇ sir.
Submits that amended appeal memo has been filed. Office to verify and proceed further. Yes.
Kindly fix the date, madam.
Post this matter for hearing.
Any date may be fixed.
Post this matter for hearing in second week of February.
Cell number 63, AC Patil for appellant, Ajit PB.
Sample response.
Yes.
Sincere apologies, I could not be present.
Yes. Yes, Mr. Paul. Yes, what is your case, Mr.
My case is very specific. My husband was the owner of larger extent of 27,716 square feet of land.
What is the survey number?
Survey number looks 67/2.
What is the extent?
Total extent owned by my husband was 27,716 square feet.
27,000?
716 square feet.
716 square feet. Yes.
But out of this extent, my husband constructed residential houses and commercial shops.
Yes.
And during his lifetime, he has sold 1,200 square feet of property to one Mr. Chikkana and other two constructed properties in favor of third parties. The property retained by my husband is the suit schedule property, which measures east to west 84 feet and north to south 218 feet.
No, is it your case that you have sold the property to that defendant?
It's not my case.
This is what the case of the trial court. Trial court has held that it is sold. All its sale deed has been admitted. Court said that this property is not a suit schedule property.
Finding. When we come to paragraph number 7 of the plain.
Yes.
Can I read?
Yes.
There are 7 paper book page number 14 alite.
Line.
Sorry, paper book paragraph number 7 is at page number 4.
Yes.
It is submitted that defendant has been attempting to interfere with the plaintiff's peaceful possession and enjoyment, asserting that he has absolutely purchased an extent of 1,200 square feet along the western boundary from the plaintiff's deceased husband. The portion of the land in survey number 67/2 situated in Madhepura village, Kerala, measuring 218 feet north to south, 84 feet east to west, including an extent of 1,200 square feet, sold to Mr. Chikkana on March 24, 1999 is more fully described in the schedule herein below, and this property is marked in the sketch.
Yes.
Paragraph 8. It is submitted that
No, that you have sold that 1,200 to Chikkana.
very same property. Kindly be permitted to read paragraph.
Yes.
8. It is submitted that defendant January 6, 1999 entered into an agreement with the plaintiff's deceased husband, agreed to purchase an extent of 1,200 square feet and complete the transaction within a period of 30 days from the date of agreement of sale, after paying the balance of the agreed sale consideration. The defendant neither paid the amount nor completed the plaintiff's deceased husband for the completion of the transaction in his favor. For the first time after the demise of plaintiff's husband, the defendant is asserting right over an extent of 1,200 square feet in the scheduled property along the western boundary. Copy of the agreement retained by the plaintiff's husband is produced here. So, submitted that defendant was not put in possession of any portion of the scheduled property at any time of under the agreement dated January 6, 1999, and the agreement dated 99 is time barred, and the defendant cannot claim any right thereunder much less interfere with any portion of the scheduled property. Defendant is influential and he is attempting to get the Kata, therefore we filed objections.
Yes.
Note, it is our specific case that in the month of January 1999, my husband has executed a sale agreement in favor of the defendant, first defendant, for sale of 1,200 square. He has agreed to complete the transaction within 30 days. He did not pay the balance amount, complete the transaction because my daughter's wedding was organized and for immediate need I agreed to sell the property. Since he has failed to complete, my husband has sold the very same property to one Mr. Chikkan. Chikkan has constructed a building. Now, my lords, after the demise of my husband,
No, that you have seeking an injunction in respect of Chikkana's properties also.
the plaint governments in its entirety,
Then
it
also-
shows that the plaintiffs are seeking injunction, including the property sold in favor of Chikkan.
How can be maintainable?
It's not maintainable. My lords, injunction can be confined, excluding the property which is sold in favor of Chikkan. And now kindly see the cross-examination of DW. And also I will take Lordship's attention to the boundaries mentioned in the sale agreement and boundaries mentioned in their sale deed.
Same.
Not the same. And what has happened, my lords, according to us, my husband has executed the sale agreement. He did not come forward. Therefore, he has sold the property to third party.
What about sale deed?
Sale deed is executed by D1 in favor of D2.
How that D1 has got?
As a power of attorney holder of my husband.
No, is there any power of
Yes,
attorney?
according to us, there is no power of attorney.
No,
except
what is the
D3.
finding of the trial court, you see?
D3 and D4 are fabricated is our specific contention.
Within the possession of the late Nagappa. Defendant number 1 had executed a sale deed.
There are 15 findings, page number 100.
Finding of the trial court. Understand? You are reading in this.
5, paper book.
Yes.
Exhibit D16, the ಮೇಲ್ಗಡೆ ಇರ್ತದೆ. Exhibit D16 encompass certificate goes to show that defendant number 1 had executed sale deed in favor of defendant number 2 with respect of 1,200 square feet of land in survey number 6. D1 has executed the sale deed in favor of his wife. So the documents relied by the defendant are pertaining to non-suit property. After the exclusion of 1,200 square feet of land in survey number 67/2, standing in the name of defendant number 2, the suit schedule property remains with the possession of the plaintiff and after the death of her husband Nagappa. The documents relied by the plaintiff at exhibit B2, mutation register extract and exhibit B3 RTC extract show that the extent of 80 plus 80 by 2 feet into 338 feet in survey number 67/2 was standing in the name of the husband of the plaintiff by name Nagappa. And as I've already stated above, the husband of plaintiff sold an extent of 1,200 square feet in survey number 67/2 in favor of D1 under this agreement of sale and GPA in favor of D1. As said, D1 has sold the said 1,200 square feet of land in survey number 67/2 in favor of defendant number 1. Hence, the suit schedule property was remained with the possession of the plaintiff's husband by name Nagappa. This certificate goes to show
See, you read here, the husband of the plaintiff had sold
this
extent
finding
of square feet in favor of the defendant number 1.
this finding is wrong. This finding is
Nobody has challenged that finding.
wrong. With great respect, I will.
Court has given a, see, the impression of the court is that this property is not that suit schedule property, therefore you are entitled for injunction. But that if you see that in that your evidence, you have admitted that
I am not admitted.
no, you have not admitted the sale. You have admitted that suit schedule properties is including the property which he has claiming. You are saying that that is not property. I may be executed an agreement, but I have not executed and sale deed. Position with you.
My humble submission, with great respect, my humble submission. specific case that I have agreed to transfer 1,200 square feet. PW1 has identified the property which is agreed to be
No,
sold
that is
D1,
true. You-
D1. And it is our specific case that we have sold the very same property to Mr. Chikkanna. Chikkanna has constructed the building. And that property is not at all available. What
No,
defendants are
no,
doing?
what is the finding of the trial court now? You have sold that 1,200 acres. That property is not a suit schedule property. Therefore, you are entitled for the injunction.
With great respect, my humble
No,
submission.
they are challenging the finding of the court, not for your case. Court has not understood that.
Correct. This finding is wrong. If I may be permitted to take Lordship's attention to cross of DW1, boundaries in exhibit D2 and boundaries in their CLD. It will clarify the issue.
What is that shows?
Notes, it is my specific case that the property agreed to be sold to defendant number 1 is sold to Mr. Chikkanna. Chikkanna has constructed the building. In their CLD, the northern boundary is shown as private property.
Yes.
During the course of cross-examination, he has admitted that northern boundary is the building constructed by Chikkanna.
No, you both are pleading something, but trial court has given finding is something that therefore order has to go. That
This finding is completely, I will respect this portion of finding is wrong.
no, entire presumption of the trial court is that you have sold that land to him. His land is different from your land. Therefore, you are entitled for the injunction. That's what that your case is that you have never sold. But the finding is one thing. Second thing, you have admitted that 1,200 square feet in part of the suit schedule has been sold to somebody else. That is some Chandrana, Chikkanna. You have obtained the injunction in respect of that property also. No injunction can be granted.
Maybe confined to injunction.
No, injunction cannot be granted partially. You have to amend the plaint.
Injunction can be confined to the extent of the remaining portion, excluding the property sold.
No, that cannot be. Show me that any judgment.
Place that.
No injunction can be granted partially. The reason is that you have to amend the plaint saying that this is my position. Otherwise, Chikkanna is not a party. He is the owner. You have an injunction. Trial court has granted.
Chikkanna is claiming under me.
No.
Chikkanna is claiming under me.
Claiming under me, you have admitted Chikkanna, you have sold that property.
Yes, I sold the property.
Now Chikkanna cannot enter his property because injunction
Chikkanna
is.
is in possession of the
No,
property.
but what injunction is there?
When I sold the property, I cannot make any claim against Chikkanna.
But that trial court has your plaintiff says that you are seeking an injunction, including that also.
Just it's my duty to protect my purchaser, therefore I have included. But my submission, injunction may be confined, excluding the property sold in favor of Chikkanna.
That cannot be. You see that injunction has to be granted as well as claimed in that plaint. That cannot be. You see that any judgment. Otherwise, I will send it back. You seek for an amendment. Then
Please.
do that. Entire finding is that he is that. Then his appeal is correct because finding is in favor of me, but degree is granted to him.
That finding is wrong.
Even now, that is what they're challenging before the court.
My submission as a
Even
respondent.
you see that somewhere ultimately what the court said. See, same is standing in the name of the defendant number 2, which is non-suit property. Therefore, I am granting in a suit.
But
See, even that by reading that, my understanding is also same. Then after going to that evidence, we come to know that you are saying that yes, 1,200 square feet is that in the inside in that suit schedule property as per the sketch.
Correct.
Then I thought that you have to be heard before passing any
My
order.
submission as a respondent, without filing a cross objection, I am entitled to argue against the pending.
No, you can.
Order 41 through 20.
You can, but you are not entitled for the injunction against that, partially against the suit schedule
Yes,
property.
my submission injunction may be confined.
No, that cannot be granted. You have to be file an amendment. You should have restraining that injunction. No, you can't take the chance, grant an injunction to entire, Vidhan Sabha. Then after that, you say that, no, I am entitled for only a part of that. That cannot be. You should be very specific when seeking an injunction. That is what the law.
Is absolutely right.
Hmm.
But considering the circumstances, my
No, that is not the law.
Come to the conclusion that I am not entitled for injunction in respect of the entire property. And if I am entitled for injunction in respect of some portion of the property, after invoking the power center under 7 Rule 7 of CPC, this court can mold the relief. Invoking the power center under 7 Rule 7 of CPC,
No, in respect.
the court can grant injunction excluding this portion, which is identified as notes 4A, Exhibit 4A in the sketch.
No, that is not the law. The person who is seeking an injunction, he should be very firm. I'm the owner of this property and I'm in the possession. You can't go on changing that pleading. That is what that law is. Yes, anyhow, that all that contention left open. Now you've taken a chance there to amend that. Yes.
My property is a vacant. The son of the court granted injunction not to change the nature of the property. Now, respondent has put up a shed in violation of the son of entry mark.
That is different. If it is violated, you can file. And now that I will set aside and send it back for reconsideration in accordance with law.
Please.
Yes.
I have the benefit of injunction from the date of the suit. That may be given to them. From the date of the suit given today, I have the
No, immediately after restoring that, everything that will be commit.
please.
That is this thing. I will only restore that
Please.
position of that suit. That's
Please.
all. Yes, by set asiding. This appeal is filed by defendant number 1 and 2. The section 96 read with order 41 rule 1 of CPC challenging judgment and degree dated 18/12/2015 passed by 13th Additional City Civil and Session Judge, Bangalore, in OS number 16402 of 2004, whereby suit filed by the plaintiff for injunction is decreed. Brief facts for the sake of convenience. Parties are referred to the ranking as per the trial court. Brief facts of the case are that land bearing survey number 67/2 situated at Mahadevpura village, Kerpuram Hobli, Bangalore East Taluk, was the ancestral property of the family of the plaintiff deceased husband, late Nagappa. Nagappa himself has filed in a suit.
Nagapati wife.
But you said Nagappa has filed in a suit.
Partition suit ಹಾಕಿದ್ರೆ ಅವ್ರ family ನಲ್ಲಿ he got the
Yes. That Nagappa filed suit for partition. In the said suit, an extent of 84 plus 80/2 feet into 338 feet, totally measuring 27,616 square feet in survey number 67/2 was allotted the share of husband of the plaintiff, and he was put into the possession of area measuring 27,716 square feet. Kata is also changed in the name of Nagappa. In the revenue records, name of the Nagappa has been continued. Nagappa has constructed residential house, residential house in the scheduled property the above said property, and he has let out for tenant. In portions of that property measuring 1,200 square feet was sold in favor of one Chandranana Chikkanna. Remaining portion of the properties was in the possession of the plaintiff husband. For the case of the plaintiff that even though Nagappa has executed agreement of sale in favor of defendant number 1 in respect of 1,200 square feet in survey number 67/2. Since first defendant has not paid that agreed amount, then Nagappa has not executed any agreement of sale, by any sale deed, and possession is also not handed over to defendant number 1. The defendant number 1 and defendant number 2, without any authority of law, try to interfere into that possession of plaintiff in suit scheduled property. Therefore, the plaintiff has filed the defendant number 1 and 2 without any authority of law. In the month of August 2004, that tried to trespass the portion of the suit scheduled property. Hence, the plaintiff has filed the above suit for injunction. Taking permanent injunction restraining defendant as his agent from interfering with the peaceful possession and enjoyment of the suit scheduled property by the plaintiff. On service of summons, defendant number 1 appear through the counsel has filed in a written statement denied averment made in the plaint, contended that husband of the plaintiff has executed agreement of sale on 6/1/1999 after receiving the sale consideration 1 lakh rupees. Subsequently, on 15/1/1999, 1 lakh rupees. Subsequently, he has also paid 25,000 and 35,000 respectively to that Nagappa. Said Nagappa has put the defendant number 1 in the possession of the suit scheduled property, and he has also executed a GPA dated 5/4/1999 in favor of the defendant. On the basis of the GPA, Defendant number 1 has executed registered sale deed dated 28/7/2004 in favor of the defendant number 2. The defendant number, the plaintiff is not in the possession of 1,200 square feet of the land in suit schedule, which has been sold in favor of defendant number 2 by the defendant number 1. Hence, he sought for dismissal of the suit. Defendant number 2 has been subsequently impleaded. Defendant number 2 has filed a written statement contending that he has purchased 1,200 square feet in survey number 67/2. Is there any relationship between 1 and 2?
Husband and wife. Husband and wife.
Yes. The defendant number 1 has sold the property in favor of defendant number 2 by registered sale deed. Defendant number 2 is in the possession of the suit scheduled property. And she is the absolute owner and possession of the property. Hence, she sought for dismissal of the suit. On the basis of the pleadings of the parties, trial court has framed following issues. To prove the case, GPA holder of the plaintiff has been examined as PW1, got marked exhibit P1 to P6. Defendant has been examined as DW1 and got marked exhibit D1 to D16. Trial court, after considering that oral and documentary evidence of the parties, answered issue number 1 to 3 affirmative and agreed the suit. Being agreed by the same, defendant number 1 and 2 has filed this appeal. So and so learned counsel appearing for defendant number 1 and appellant, learned counsel appearing for the appellant defendant number 1 and 2 contended that in portion of the suit scheduled property, that is in survey number 67/2, 1,200 square feet, the land has been purchased by defendant number 2. Plaintiff husband has executed sale agreement after receiving sale consideration amount of 1 lakh. Subsequently, he has received 25,000 and 35,000 from the defendant number 1, and he has executed a GPA in favor of defendant number 1 dated 5/4/1999. The defendant number 1 has absolute right over the property. On the basis of the GPA, he has executed registered sale deed dated 28/7/2004 in favor of defendant number 2. Hence, the defendants are in the possession of the suit scheduled property.
Property,
Their position, they are in the possession of part of the suit scheduled property.
1,200 square feet.
Huh?
After a P4A.
Yes, yes. The plaintiff has no right or title over 1,200 square feet the land in survey number 67/2. The trial court has rightly given a finding. The trial court has rightly given a finding that plaintiff husband has sold 1,200 square feet of the land in favor of defendants number 1 and 2 in survey number 67/2.
Given but I am challenging that.
Our finding, our the argument.
They believe finding another.
Our argument he is saying rightly said.
Correct.
His argument. He has submitted that.
Let's contention and the trial court should not feel that it is a bending of this one.
No, I am recording his arguments, Mr.
Please.
Yes. But error in degree the suit. He further contended that considering that evidence of the parties and record produced by the parties, it is very clear that 1,200 square feet of the land which is purchased by defendant number 1 and 2 is the part of the suit property. The trial court is the error in held that property purchased by defendant number 1 and 2 is not the suit property, and error in granting that injunction in favor of the plaintiff. Therefore, he sought for allowing that appeal. For contra, learned counsel appearing for the plaintiff respondent, the specific case of the plaintiff that husband of the plaintiff has executed agreement of sale in favor of the first defendant on 6/1/1999. Since first plaintiff has not paid that sale consideration amount, the husband of the plaintiff has not executed any sale deed in favor of first defendant, much less no GPA has been executed in favor of the first defendant. He further contended that GPA produced by the defendant is concocted. It is not executed by the Nagappa, who is the husband of the plaintiff. He further contended that the very same property, that is 1,200 square feet in survey number 67/2, which is belongs to the Nagappa, has been sold in favor of Chikkanna by registered sale deed.
Registered sale deed, I have specifically stated. Registered sale deed dated notes, date is also mentioned in paragraph number 7. 24/3/1999.
24/3.
1999.
1999. 24/3/1999. Therefore, he has contended that defendants 1 and 2 are not in the possession of the suit scheduled property. He further contended that at no point of time, plaintiff husband Nagappa has parted the possession in favor of defendant number 1. In fact, they have sold that portion of 1,200 square feet in favor of Chikkanna and possession has been handed over. Further contended that taking that agreement of sale dated 6/1/1999, which is time barred, the defendant number 1 and 2 are tried to interfere into that suit scheduled property. Therefore, the plaintiff has filed the suit for injunction. He further contended that even though suit scheduled property includes 1,200 square feet, which is sold in favor of the Chikkanna, the claim of the plaintiff for injunction excluding the 1,200 square feet. The trial court, after considering that evidence of the parties and material available on record, has rightly granted an injunction. Hence, he sought for dismissal of the suit.
Dismissal of the appeal.
So, dismissal of the appeal. Heard the learned counsel for the parties. Perose, judgment and award, judgment and degree. The point for consideration, whether judgment and degree passed by the trial court is perverse, arbitrary, contrary to the law, all for interference of this court. It is not in dispute in the partition. The Nagappa, husband of the plaintiff, has acquired 27,716 square feet in survey number 67/2. It is also not in dispute. Nagappa has sold 1,200 square feet of the land in favor of Chikkanna by a sale deed dated 24/3/1999. It is also not in dispute that plaintiff husband has executed agreement of sale dated 6/1/1999. The further case of the plaintiff that since defendant number 1 has not paid that agreed amount as per that agreement of sale, that Nagappa has not executed any GPA nor parted with a position to the defendant number 1. The case of the defendant that pursuant to that agreement of sale dated 6/1/1999, the first plaintiff has paid 1,65,000. 1,65,000 in favor of 60,000. 65. 25. 60. Yes. 60,000 in favor of Nagappa. Nagappa in turn has executed in a GPA in favor of the defendant number 1.
Declaration.
Huh?
He executed a declaration deed, 5/4/1990.
Yes. Was executed in a GPA ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ 5/4/19.
Declaration
Yes. GPA dated on 5/4/1999. On the basis of that, defendant number 1 has executed a registered sale deed dated 28/7/2004. The said 1,200 square feet, which is mentioned in that agreement of sale dated 6/1/1999, is also suit scheduled property. The defendants are positioned in the suit scheduled property in respect part of the suit scheduled property. The trial court has error in granting that injunction. Next para. The trial court by giving a finding in respect of the case of the parties has given a finding that the property which is claimed by the defendant number 1 and 2, that is 1,200 square feet, is not a part of the suit scheduled property. This is not the case of either the plaintiff or the defendant. The case of the plaintiff that they have not executed any GPA in favor of the defendant number 1. 1,200 square feet in the suit scheduled property has been sold in favor of Chikkanna. The case of the defendant number 1 and 2 is that 1,200 square feet in the suit scheduled property has been sold in favor of defendant number 1 and 2. Both the parties are claiming that 1,200 square feet in the suit scheduled property is a part of the suit scheduled property. The trial court, under the impression that 1,200 square feet is not a part of the suit scheduled property, and has granted an injunction order. This finding of the trial court is contrary to the pleadings of the parties. The specific case of the plaintiff that he has sold 1,200 square feet of the land in survey number 67/2 in favor of Chikkanna. It is a part of the suit scheduled property, and it is also not disputed that Chikkanna is in the possession of the property. Under that circumstances, trial court is error in granting an injunction in favor of the plaintiff in respect of entire suit scheduled property. Therefore, finding of the trial court is contrary to the material available on records. The judgment and degree requires to be set aside. Send it back to the trial court for fresh consideration in accordance with law. Accordingly, the appeal is allowed. The judgment and degree dated so and so passed by the trial court is set aside. The matter is remitted back to the trial court with a direction to reconsider that matter afresh in accordance with law, without influencing any observation made by this court in this order. Yes.
Parties may be permitted to
Appear. You can appear without any further notice. When will you appear?
permitted to file necessary applications and lead
I think you can do-
additional evidence if necessary.
I have not said do it in accordance with law.
ಕೆಳಗಡೆ ಕೂಟಲ್ ಕೆಲವು ಸಲ ಲಿಬರ್ಟಿ ಕೊಟ್ಟಿಲ್ಲ ಹೈ ಕೂಟಲ್ ಮಾಡಕ್ ಬರೋದಿಲ್ಲ ರೀಕನ್ಸಿಡರ್ ಇರೋ ಮೆಟೀರಿಯಲ್ ಮೇಲೆ ಮಾತ್ರ ನಾವು ಆರ್ಡರ್ ಮಾಡ್ಬೇಕು ಅಂತ ಬರ್ತಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು.
And if the parties are at liberty to file necessary application or use necessary evidence, both the parties.
Entry matters will be restored.
That is automatic, Mr. Yes.
Well,
The parties are there.
documents are standing in my name. He is asking entry
From day
No,
one,
I am not.
So from
See,
day
I
one,
am-
I have the benefit of.
I have set
injunction.
aside
From the date
and-
of the suit.
No,
From the
I have-
date of the suit, I have the benefit.
I have
of
set
injunction.
aside and restore the suit. It is for you both to see that whether it will be restored or not has to be before the trial court will consider. Yes. You will appear before the trial court. Any further notice? Both of them.
ಬೇಕಾಗಿಲ್ಲ, ಬೇಕಾಗಿಲ್ಲ.
When will you appear? The parties are directed to be appear before the trial court on 20th February 2024 without any further notice. Yes.
Direction.
Dispose ಮಾಡೋದಕ್ಕೆ ನೀವು ಅಲ್ಲಿ ಮತ್ತೆ evidence adu idu ಮಾಡ್ತಾ ಕೂತ್ಕೊಂಡ್ರೆ it will take time. The trial court is directed to dispose of the suit as expeditiously as possible 1 year from the date of appearance of the parties. Yes.
Adinarayana for appellant, Guru Prasad R. Number 1, Adinarayana.
Post ಆಗಿರ್ತಿದೆ. In spite of granting 6 time for complaints of the office objection has not been complied with. Even the matter is posted before this court on 8/1/2024. In the morning session, none appear for the appellant, and in the afternoon session, there is no representation on behalf of the appellant. Directed to post this matter for on 10/1/2024 at the top of the list for orders. Even today, when the matter is posted for yes, when matter is posted on 10/1/2024 in the morning session, none appears for the appellant. In the afternoon session also, no representation on behalf of the appellant. Office is directed to release this matter on 11/1/2024 at the top of the list under the caption for dismissal. Even today, when the matter is posted for dismissal, when it called in the morning, none appear for the appellant. Even afternoon session, none appear for the appellant. It appears that appellant is not interested in appeal. Hence dismissed for non-prosecution.
Serial number 2, Sudeep S. for appellant, Murali M. Serial number 2.
None appear for the appellant. As a last chance, 2 weeks time is apply the top subjection.
Serial number 10, Vijay Lakshmi SP for appellant.
Register in the appear again. Objections. Right of granting sixth time to comply the top subjection. Office objection is not complied. None appear for the appellant before the register when the matter is posted for compliance. Before non-compliance, before the register for non-compliance. Even when the matter is posted before this court today for non-compliance of the office objection for fixed time, when the matter is called in that morning session, none appear for the appellant. Even afternoon session, none appear for the appellant. Leave this matter Monday, Tuesday at the top of the list under the caption for dismissal.